I'm sitting just outside Munich.
Ah, okay, right on. Yeah, because they have all those locations down there, right? They have some of those telescopes. I don't think you're manning the fort down there.
Okay, so I'm just trying to rearrange my screens here. Okay, so let's see if I can share this now. Share content. Screen 1. So it's that one. Yeah,
we see it. It's very good.
And it's in that's in presentation.
It's in the full screen. It's in the full thing, so we can see the like presentation mode.
Okay, fantastic.
Okay. Excellent. All right, that's excellent.
Thanks. Well, I'm going to grab a cup of coffee, and I'll see you at 3.
Do that. Yeah, thanks so much, man. This is great. Thank you.
Sure.
Okay. Okay, streaming is ready on this. Is this what you have here? Okay, let's see. And then, yeah, you put me, okay, this is good.
I'll put you now as, I will change it completely to host.
Okay.
I guess you know everything just for the interpreters, how to do it or whatsoever. If any issue, you can always, because I'm not disconnect, as I said, now I'm at Palais Coburg, so I need to move from one place to the other. And that's why I don't know when I will be immediately reachable, but my colleague Francisca, she can always connect and whatever you need.
Okay. I think we're gonna be okay.
Yeah, it should be fine, should be straightforward. As I said, that's why I'll give you, I'm just waiting also for someone else maybe to come so that you can assign him as a co-host, because it's always safer in case if your connection was broke or something, so that you immediately can you know, the connection will stay online. Because if both of us, you know, we log out and there's no host anymore in the meeting, it will stop the connection. That's why you need.
What was that again? I'm sorry, I didn't catch that last part.
You need to have a host and a co-host in case your internet connection got broken in between.
Okay.
So you're normally out, and if there's no host or any co-host anymore in the meeting, it's normally just terminates the meeting. So that's why I guess Sebastian.
We can make Magdalena a co-host. She's trusted.
Yeah. Okay. So.
Hello there. Morning.
Hello.
How are you?
Sebastian, so good to hear from you. Yes, well done yesterday. I know that it was quite difficult. I know that there were audio issues and all sorts of things. And I think you did, for at least from my side, you did a great job. But you know, I know that things were difficult. Well done.
Yeah, it's part of the job. Good thing
really
is that
and I know that the others are too. And today we are going to have a or is it tomorrow? I think it's tomorrow that we have our presenter from Mexico, and I think she's going to do it in Spanish. So this is good also. It's great to have you. Thank you.
Okay, no problem. Also, if you get the presentations for tomorrow, please, if you can also share those with us.
Let me see. I don't have so many of them. I have the presentations for today, but I didn't send them to you. Oh my gosh.
No, don't worry. It happens though.
Sorry, it was getting a little bit hectic around.
Oh yeah, I presume.
Do you want me to send those to you now, or
please.
you and Maria?
It's still useful. Please, if you can send those to us now.
Okay.
Yes, please. We can still review those as
let me just do this real quick.
Hi, sorry, Michael. Just a question. Sebastian, I guess he's the interpreter, no?
Yes.
Okay, I'll change his role also.
Me and Maria Paz, yes.
Maria Paz, okay, because Maria Paz, she's just signed in as attendee, so I'll move her also to be a panelist. Okay, so and I'll change both of you to be.
You hear me now? Yes.
Yes.
Yes, we can hear you.
Okay, great.
I was just telling Sebastian, Maria, I was just telling Sebastian how much we appreciate your good work.
Yes, I heard. I just wasn't able to unmute myself, but I heard.
I'm telling you, it's really appreciated. I mean, it really is. Very much so.
Thank you.
Let me just send you these presentations that are gonna happen today. I'll just do this now. I'm sorry I didn't do this before. I just received the last one not too long ago, actually. And we don't have the first one anyway from my colleague on the registration, but it should be pretty straightforward.
Yeah, it's okay. You have much work on your hands, so
Exactly.
There's juggling everything, but this is the world we live, you know, this is how we do it these days.
Sorry, Michael, this is
Yes.
Andy Williams here. I just wanted to let you know that I just sent over my presentation, and there's actually some script in there, which is more or less what I'm going to say. So I hope that's helpful for the interpreters.
Okay, great. Thank you. Thank you very much. I haven't received it just yet, but let's see when it comes here.
Yeah, it's quite a big attachment, so it might take a while.
Okay. I'll keep my eyes peeled, and if I have to send another mail with that one, then I'll do that one.
So, Michael, sorry, interpreters already set now, and you got now the host role.
Yeah, the host, yeah.
Magdalena, she's also a co-host, and she can also then move people if from attendee to panelist and whatever. So I'll be just, as I said now, just leaving the.
Thank you very much. Thank you,
Okay.
Mohammed. This is
Okay,
very
thanks.
helpful. And we'll talk after a while. Let's catch
Sure.
up after a bit if we need to, okay?
I will. Super. Thank you.
Thank you, Mohammed.
Hello, everyone. How are you? Can you listen to me well?
Yes, we can hear you. Is that what were you speaking, Magdalena?
Yes.
Okay. Okay, now I hear you. Sorry, but yes, excellent. Yes, Andy, I got yours now. Okay, this is
Hello, everyone. Can you see me?
hello, Christina.
Hello, Christina. We can hear you, but we can't see you.
Yes, we
now,
don't see you. Yeah.
can you hear me?
Yes, we can hear you, but we can't see you. Now we can see you. Yes.
Michael, are you speaking?
I'm not speaking. Okay, I'm now copying back these presentations to folks, to you, Sebastian and Maria. Just, but Andrews is a link, but that's okay. Let's see. All right. Okay.
No, Cristina, no te escuchamos, te vemos, pero
Ahí
no
te
te estamos
escucho.
escuchando.
Ahí te
Ya, ahí sí,
escucho.
ahí estás,
¿Sí?
ahí te escuchamos
¿Ahí
súper
sí?
bien, sí.
Ya, algo pasó. Ya, entonces ahí me ven.
Te vemos, te escuchamos, pero parece que el internet es inestable porque te quedaste pegada.
¿Aló? ¿Aló?
Ya, sí, el internet que
¿Sí?
tienes es inestable porque te quedas pegada.
Ah, ya. Pucha, ayer no tuvimos estos problemas, pues caramba. ¿Y ahí sigo pegada?
No, como que va y viene.
Ah, ya.
Intermitencia de internet.
Ya. Puede ser la hora. Maldito internet. Ya, igual, espérate, déjame.
Cruzo los dedos para que eso sea solo ahora.
Claro, que sea así, idealmente ahora y no después, ¿no? Ya, igual voy a como desactivar todo que no sea esto. Ya. A ver si funcionamos mejor.
I'll come right back in just a second. I'll just be.
Okay.
Okay.
Magda, si cachai que me quedo pegado o no me escucho, me mandé un mensaje por WhatsApp para moverme, ¿ah?
Sí, no te preocupes, y ahí te cubro yo desde acá el
Claro, ¿ah? Obvio que ayer no tuve ningún problema, pues, ¿ah?
No, pues ayer estuvo súper
Sí, pues súper fluido.
súper bien todo.
Ya, pero
Pero
esperemos que sea solo.
ayer estabas con celular, hoy estás con computador. ¿Puede ser esa la
No, con
diferencia?
celular, estoy exactamente igual.
Ah,
Porque este
mira, por
computador.
ahora ha andado súper bien.
Bien.
No te has quedado pegado.
Ya, bacán. Sí, de hecho no, porque el computador fiscal no, mira, es un tema y claro, si conecto el mío con la señal del teléfono ahí sí que no funca, así que vamos a cruzar los dedos, que sea igual que ayer.
Sí, va a funcionar, va a funcionar.
Exactamente.
Hi, Tertia, I see you there. How are you today?
I'm good, thanks, Michael.
Excellent.
We
Excellent.
starting on time?
Yeah, it seems that we'll be starting on time.
Okay, great. I'll be here.
Thank you very
Okay,
much.
cheers. Bye.
Hello, Lovo, how are you? How are you doing?
Hi. Oh, let me see if I can work it out. Hi. Hi, good afternoon to everybody.
Hi.
Good morning on here,
Good
Brazil.
morning.
Morning.
Thanks again for the invitation, Michael.
Absolutely. We're glad to have you. Very glad. You carry the torch for Professor Montserrat Filo on this one. This is
Yeah.
for many, many years we worked with him closely.
Yeah, this is one of the topics that he's always been studying, and since he chaired the working group for definition delimitation for such a long time,
Yeah.
he always loved this topic. And it was because of him that he started to do research on this topic.
Really?
Yeah.
Yeah.
Yeah. He asked me to help him in his job as the chairman of the working group, and then I decided to cover this topic for my PhD here in Brazil.
All right.
And I've been studying it ever since.
Well, it's been, as you know, it's been one of the longest topics discussed ever in the entire history of space, actually, the definition delimitation. It's really something, actually. It has a long legacy.
Yeah, that's what I'm gonna say. I'm gonna say that it's the oldest open question in space law.
Point that out because it really is.
Hello, good morning
Hey,
to my friends in South
Hamza.
America. Hello.
Oh, so great to see you, Hamza. How are you?
Doing well, Alavo. Good to see you as well. How's everything going?
Good morning.
Everything's going okay. So great seeing you again.
Yes, thank you. You too. And good morning, Christina. Good to see you.
Good morning, Hamza. Nice to meet
Morning.
Too.
Good morning to you all.
And Michael, how's everything in Vienna?
Oh, it's a wild ride, let me tell you. No, it's good. We got sunshine, so it's positive. It might
That's a
not be
good
Rome,
thing.
but it's not bad.
Today's the first day that I'm using my air conditioner.
Yeah. I've used it so much that now mine is broke. So let's see how it goes.
Luck with that because it's necessary.
So should we start?
Absolutely. Whenever you're ready, we can definitely start.
Okay, I'm ready. If you guys are, let's do this.
Christina, did you want to lead off?
Okay, I'll
You're
start.
more than welcome to.
Okay, should I just go?
Yes.
Okay. So, good morning, good afternoon, buenos días, buenas tardes. Distinguished participants, dear speakers, I welcome you to our second day of the United Nations Chile Conference on Space Law Policy, Governance, and Legal Perspectives on Space Activities in Earth and Beyond. My name is Major Cristina Fabri from the Chilean Air Force, and I'll be your moderator today. Yesterday, we covered an overview of the legal regimen of outer space and governance. Today, our presentations will be oriented to the perspectives on space traffic management and the governance of outer space activities. We thank again all participants and ask you to disable your cameras and microphones so we may move more smoothly through the program. Therefore, please post your questions in the chat and we will pass them to our speakers after their presentations. Without further talk, I introduce you to Natasha Rodriguez from UNIOSA, who will be presenting in the United Nations Register of Objects and the question of mega constellations. Natasha, the floor is yours.
Thank you, Christina. Hi. Do you want my camera on or you want my camera off? I'm under your guidance, as you wish.
Are you going to be presenting?
I will be presenting, so I'm just going to share with you, and you tell me when you can see it.
Okay.
Please, Natasha, with your camera on, I think for the interpreters
yeah.
it would be very helpful. Thank you.
Okay, so
there we go.
Can you see me? Because I think I haven't enabled my camera now. Hang on, hold on a minute. I need to go back to where it was before. Oh boy, now you're asking me.
We see the presentation.
You see the presentation, but not me.
But not you.
And now I don't see my presentation. I've managed to knock myself out. All right, just give me a second. There we go. I can see myself and camera. Tertia, come on. This is not difficult. Oh, start video. There we go. All right. Okay. The gray hair speaks for itself on the new technology. All right, everybody, I assume you can see my presentation and you can see me. Is that correct?
Yes, we can. Thank you.
Okay. All right. So I won't keep you any busy. Let me just introduce myself a little bit. I'm Natasha Rodriguez. I work for the Office for Outer Space Affairs. I oversee the team that deals with the United Nations Register on Objects Launched in Outer Space. Today's session, I am aware that you are dealing with elements of space traffic management, but I will take you through some of the basics on registration of space objects, identification of objects, and then just a few slides on how Constellations is being dealt with currently in terms of bio-member states who are launching them in terms of registration, and I'll provide you with some information. So without further ado, let's see. So just a quick introduction. We'll have a quick introduction for the benefit of those colleagues may have know a lot about the United Nations registration. I'll just do through some of the basics for the moment. So space object registration is probably one of the earliest things that member states were concerned with right at the beginning of space exploration. And the main objective towards the decision to come up with a registration system was in order to facilitate the identification of space objects. Now, this was started quite early on in the process. The first of the instruments, that's the word I'm looking for. The first of the instruments that the General Assembly adopted on registration of space objects dates back to 1961. It's Resolution 1721B. I've taken the trouble to highlight this for you, of course, because it is still very much a relevant instrument in terms of dealing with registration, because it remains the voluntary mechanism that member states still use today when they are not parties to the registration convention. So basically, a few years later, we had elaboration of the various treaties, the fourth of which was very much a focus on the registration aspects that member states were interested, and we had a registration convention come into force in 1976. And that now became a mandatory, or let's put it this way, no longer a voluntary mechanism, but any state party that were to ratify the treaty would then have obligations under that treaty, and it became mandatory. So currently today, we've got two registers. In fact, we still have two registers, one that encapsulates all the information that we receive under voluntary, the 1721B register, and then of course the register that encapsulates all the information that we receive under the registration convention. So very quickly, I'll go through them very quickly. The registration convention provides quite a bit of information to parties who need to register their space objects, either voluntarily or through the registration convention, while the 1721B resolution does not actually give a lot of detail in terms of how, what, who, and so forth. A lot of the member states who do so voluntarily do rely on the information that's in the registration convention to guide them in terms of what they register. So you'll have information, you'll find in the registration convention some guidance on space object, what it includes. In terms of our practices, we often have, obviously we have operational satellites. We also have failed satellites being registered. You'll find information on rocket stages, boosters, payload adapters. You'll even have some space debris being registered. I do want to give you fair warning that member states interpret the concept of a space object very differently. So there is variations on the interpretation from state to state. The other important goal of the registration convention also is to connect it to the issue of responsibility, which links it to Article 6 of the Outer Space Treaty, which defines that for us, a state bears international responsibility for national activities in outer space. That means they're responsible both for the governmental space activities and non-governmental entities who conduct space activities. And then there's the added responsibility that the non-governmental entities do require authorization and continuing supervision by the member state in question. I do want to share with you that it does occur periodically that we will find that a member state may not always be aware of the non-governmental entity that is planning to conduct or is conducting space activities, and sometimes there is a little bit of a disconnect, which we then facilitate. So who registers? A space object is registered by a launching state who carries the object on their national space object registry. In other words, so there's the United Nations International registers rather, and then there's also at the national level, a national space object registry. And these have to be established and maintained by the respective member state. The concept of the launching state defines there's information on what is a launching state in terms of those who are either launching the object or procures the launch of the space object, a state, or it also constitutes a state from whose territory or facility the object is launched. All of that contributes to who gets to register a space object. The state of registry can get complicated in terms of when you have launches with multiple states involved in a particular launch, so many launching states for a specific object. But there is only one state of registry that we usually record. Occasionally we do get more, or usually two member states who will then submit registration documents. Usually we then go back to these member states and then they have to coordinate that internally to say who then remains the state of registry. I'll leave it at that for now. Then what information to provide? Article 4 is the guide to that. Very obviously, some of it's fairly self-explanatory, but some of it needs to be clarified. We obviously need the name of the launching state or states. an appropriate designator for the space object or registration number. So that's designator can be a national designator. Member states deal with this in different ways. Some have national designator numbers, some use the International Coastguard designator. So there's a variety of approaches towards this. Obviously, date and territory or location of launch is important. Then the basic orbital parameters, including the nodal period, inclination, apogee, and perigee. A description of the general function of the space object. We also then have sometimes member states give us additional information that a member state may give. So sometimes that information could be changes in the orbit, or maybe something got deorbited, then we get additional information under the registration convention. And of course, I've already mentioned this, when the object is deorbited or has re-entered, then we ask for the date of re-entry. When to provide it, Article 4 doesn't give you a very clear designation. It says as soon as practicable. In terms of practice, and then there's a lot of questions arising to this, but I won't go into that too much. But we would recommend at UNOOSA, based on the general practice of member states, to register as soon as possible after the launch with the intended operational orbit. So a lot of member states sometimes hesitate with submitting the registration documents immediately after launch because the object hasn't reached the designated orbit yet. You can always send the registration documents to us, provide us the initial information, and then send us an update of the information, and that information then gets disseminated. So you can always provide an additional notification letter. There are some interesting scenarios with when do you register an object, for example, that gets sent to the International Space Station, as an example, is there for a little while, and then a few days later eventually gets launched from the International Space Station. But we have relatively good practice and information that we can provide on that. So that brings me to mega constellations. It's a pretty hot topic lately in terms of, for a number of other reasons, but in terms of registration, obviously mega constellations are for specifically, and the impact of mega constellation launches is important for us in terms of registration, obviously in terms of volume. There isn't really at this point, I think, an agreed definition of what constitutes a mega constellation, but the way we look at it in terms of the characteristics are usually, the typical characteristics are they're either in, low Earth orbit or medium or the middle Earth orbits. The numbers that are currently floating around in terms of what may be coming, we draw this information from the ITU advanced publication information. So in and about from between 100,000 to 300,000 satellites are expected to be launched in the next 10 years. Probably the 100,000 mark is probably more likely, but it could be as high as 300. These are just estimates. The launchings are coming from commercial services for global coverage, for example, internet and so forth. It usually involves one particular satellite operator who's launching multiple satellites. They're mass-produced, the objects, and then there's a regular replenishment of the objects. So as some of the objects are in replaced. Large constellations, very roughly, are seen as anything between 100 objects and 1,000 objects being launched at any time. Examples of Flock and Astrocast. Mega constellations means planned launches of over 1,000 satellites in a particular group, Starlink, OneWeb, Kepler being examples. Presently, only OneWeb and Starlink have significant number of satellites in orbit. I wanted to give you this graph. So it gives you a sense of what has been launched and what is currently in orbit. Obviously, some of the objects have been deorbited or not operational. So you can see in terms of there was a steady growth in terms of what was launched, and then obviously fairly, how can I say, steady growth in terms of both in orbit and launched. But then from about 2015, 2017, then with all the additional satellites being launched, you can see how extensively that climbed and how fast it climbed in only a few short years. I can tell you that in about 2015, USA was registering approximately 300 satellites a year. In 2021, we registered over 1,800 satellites already. And last year, we also had about 1,800 that were launched. 80% of those satellites that were registered last year were large or mega constellation satellites. So there's been quite a significant increase. Currently, in terms of the population, based on the information we have, we've got about 8,700 objects in the 3 orbits, of which 5,800 are operational. Estimates roughly for 2022, based on the data and the registration documents we've already received for this year, we expect that we will exceed the number of 2,000. And approximately by 2030, 2032, I think the rough estimate at this point is that we may have as many as 100,000. So that brings us to the question. So what's happening in terms of registration on mega constellations? Are the responsible member states and the states of registry being compliant? So at the moment, I can confirm that the UK and the USA do register the large number of satellites that they are being launched under those constellations. Both the states have reviewed their registration practices and identified areas to improve their efficiency. They've also been in touch with USA in terms of facilitating registration and the mechanisms. Common practices that I can mention are increased frequency in registration submissions. In terms of the increased submissions, the UK does it pretty quickly, soon after launch. The UK is more of a cyclical approach where they do all the registrations on a monthly basis and they do the constellations they are. In order to facilitate the volume of registration, obviously, there is a spreadsheet that's available to the states of registry where they can provide the information in mass form rather than doing one form per object, especially when the numbers are at the level that they are currently. In terms of basic orbital parameters, UK parameters provide the parameters of the final orbit and the planned date. The US provides the initial orbital parameters. So in itself, you can see that there are different approaches from member state to member state registration. Then the additional information that we find that our mega constellation states of registry are providing, the UK provides the date when OneWeb satellite was deemed non-functional, for example. The US provides the dates of re-entry for the Starlink satellites that decay or deorbit. So recommendations for registration of mega constellations. And let me stress one point. These recommendations are precisely the same as to whether you're registering one satellite or you're registering 100 satellites at a go. With one slight additional difference, we would recommend the COSPA International Designator. We obviously would like the information of the common name of the space object. We recommend using UTC for time and date of launch for the simple reason that then there isn't the differences between, if an object is launched in Russia or an object is launched in the United States, it could differ by as much as 1 day, depending on what it is in terms of the information being as accurate as possible. We do recommend the provision of the expected date when the space object will achieve its operational orbit. We recommend information being provided on the space object owner or operator. Additional information relating to the change of status of the space object, such as, if an object is launched, for example, I think it was Starlink who experienced a space weather event that then resulted in a number of their satellites deorbiting quickly and re-entering. That information is recommended to be provided. The other element that USA highly encourages our mega constellation states of registry is to give us information on the constellation itself that we can share. and be inputted into the registry. And then, of course, we recommend the use of the spreadsheet format to submit the information. It's both helpful for those who are having to prepare the information and also for us as a secretariat having to process that information. Then, just to close off the presentation, what does registration look like today? What's the status of registration? We've got 72 state parties and 3 signatories who have signed up to a registration convention, including 4 intergovernmental organizations who have stated their acceptance of the terms of the treaty, and they then comply accordingly. We've got approximately 12,900 functional space objects launched since Sputnik 1. So that's how many have gone up since the advent of space exploration. Comparably, we've got approximately 89% of those that were launched have been registered. Convention non-parties are, I've already mentioned this to you, convention non-parties are providing the information under 1721B. So irrespective of whether they're party or not to the registration convention, we're still getting quite a lot of information from even the non-parties. Currently, I've already said to you that we'd received over almost 1,900 registrations in 2021. At the moment, as at May, we're sitting at about 700 registrations received. So we are expecting to exceed the 2,000 mark. We're anticipating it in terms of the trends. Then there's always that magic question, what does registrations include? There's always the curiosity about military and national security satellites. Yes, some member states do provide the registration for their military non-security satellites. We do get information on in-orbit failures, registration, and we also get registration documents for objects that were launched for some and have already re-entered. Sometimes objects are launched, they're there for a short period and re-enter. We get the information on those objects even after the object has already re-entered. So we encourage that. The one thing that the UN register does not provide you with is real-time tracking at this point in time. That's what it looked like in terms of the blue line is those that have been launched. The yellow line is the information that we've received and is contained in the registers of the United Nations. There is a slight bigger gap here, which is closing because there was a period where some member states were going through some internal reorganization and review of their registration practices. So the information was coming in a little bit late, but there's been a very good catch up on that. So that brings us to approximately 89% as at today. Of course, tomorrow, Starlink launches another 100 or so satellites. These values actually fluctuate quite extensively from week to week sometimes. Then my last comment, and I won't go into what's on the slide, you can read that afterwards, just to leave you with some practical registration resources. And also, thank you very much. And please feel free to contact us if you need any information or you need to know more information about how to register space objects. And that's where I will stop.
Thank you, Natasha. Very interesting. We have some questions from our attendees. One of them is, how can we avoid forum shopping by privates who want low jurisdiction?
How can we avoid? Can you repeat the question?
Shopping, yeah. How can we avoid forum shopping by privates who want low jurisdiction?
Authorization and supervision. It's very simple. I think member state. It's not so simple. Sorry, it's a simple answer, but not such a simple thing to do in practice. Look, member states have a responsibility towards supervising and authorizing space activities conducted by entities that are either registered or incorporated in their national jurisdictions, or fall into the how can I say, the concept of the state of registry or the launching state. Yes, there have been instances, I can confirm at least one case where maybe possibly there was forum shopping. I can't speculate on that, but there was an instance where we became aware of the fact that a specific entity launched with another member state, but then the member state that oversaw, or at least in which they were incorporated, obviously there were penalties that were dealt with in terms of they've got a very robust national space legislation and authorization mechanisms. There were some penalties imposed on the member state, and of course, subsequently, the member state actually did take on the responsibility of state of registry. This is one of our state of registry, got quite a bit of experience in doing that, but very simple. If you want to stop from shopping, I think member states need to elaborate what the requirements are at the national level, put in the rules and regulations, develop the mechanisms that will, how can I say, prevent some of that flags of convenience, if one has to put it in terms of the maritime context. So I don't know, Michael, you're my space law specialist. Perhaps you can amplify my answer better.
No, that's exactly right. It goes to implementation of Article 6 of the Outer Space Treaty, and you're absolutely correct with that. And also the requirements that go into how a country corresponds with its non-governmental entities, what information it seeks, and then what information it puts into its own national registry regarding those space objects, and then what it transfers to us. So it really is. There is a real give and take. There's an interplay between the government and the private sector entities that they regulate that is extremely important. And to have that open communication throughout is incredibly important at the national level and those operators. Yes, we have another question for you. What are the consequences of not registering space objects?
Does the registration convention or the treaties provide mechanisms to, I think this comes to, is there penalties? Is there something that happens when a member state doesn't comply? The registration convention is silent on that. And I think the treaties in general are silent on that. But there is, I think, a very general... Based on the compliance rate, which is at 89%, and given the volume of satellites that are going up, I think there is, a level of responsibility that's associated to member states who are very engaged in space activities. The issue of identifying a space object touches on a number of legal issues. So the connectivities and how these things work within the treaties, I'll let Michael elaborate on if he chooses to wish to, but it's got to do with liability. It's got to do with identification. It's got to do with responsibility. And in order for you to be able to, establish that certainty in terms of the legal frameworks, you need to be able to identify the object. And it's mutually beneficial for every member state. Yes, I know some member states need to do a bit of, some are much more experienced in this. Some member states need to understand how this works and the importance of it. And this is what a lot of these space law capacity building activities are about. That's one of the reasons why we are so heavily invested in supporting in Chile, who's joined us on this journey for a few times now, is to get that information there, that this is important and why it's important. I don't know, Michael, do you want to add anything else?
Oh, no, I think you really summed it up. Absolutely. One thing that there's another question here that I think really speaks to some of the nuts and bolts of what we do is what happens if a space object is detected and not registered?
I was just about to come to that actually. US has got it's got something called an online index. Now, the online index is not the register. It's a tool that we have on our website, and we keep track. We use a lot of open source information. It's not like we're connected to some government entity or agency. So we rely very heavily on open source information. And when there's information that an object's been launched, and we kind of can sort of establish that information from multiple sources, we enter the information on the fact that an object has been launched into the online index. Now, the online index is essentially a database, and the database gives you little colors, if I have to put it very simply. So we indicate when an object, then when we are aware of an object has been launched on. If it's been registered, there's an indication that the document has been registered, and we either give the links to where the document is registered and where you can find the information and so forth. If it's not registered, it's indicated it's not registered. So at any time, a member state can go onto the online index and say, and we, based on the information we have, we sometimes indicate who may be the state that needs to sort of catch up. So there is this online index. It's a very practical tool that we launched, and we do an incredible amount of what I like to refer to as soft diplomacy with our member states. When they come to our legal subcommittees, when they come to our STSCs, you know, with our intergovernmentals, we see the delegations, or even with the permanent missions, we're often saying, hey, you know, there's a whole bunch of these satellites. Why are you not registering? Is there a problem? Do you need help? So there's a lot of proactivity in terms of the Secretariat, the registration Secretariat does with member states, because for us, it's really important to keep the registration rate up, because it all ties in with all the other obligations, the responsibility, and all the other issues that, of course, is important to us in terms of the legal community. So the online index is the first stop. Once you have that information, if you're a member state, if you're a government official who goes, oh, there's an object that looks like might be my country's, and what should we do about this? Pick up the phone and call us. We can guide you. We can find out if there are constraints. Sometimes it's just connecting the dots, connecting the focal points. But the online index is where you can probably find the first sense of information of objects launched, not registered.
That's excellent. Thank you. And that really goes to the heart of a lot of what we do, is working with member states on this. And just another question before I think we might have to move. Just on this one, let's see. Taking into account the particularities of the registration of military satellites and potentially the non-obligation to register, what drives a country to register or not? And the gap in the graph that you showed, can you explain maybe some of the reasons why states might not register?
The gap in the graph, obviously with registration in the early years, we had a bit of the gap because we had the voluntary registration in terms of objects. 1961, we had the voluntary, but that took some time for everybody to get used to and the practices. So in the early years, we had the very first whole bunch of satellites that have since probably re-entered. I think not all, but re-entered, that were never registered because we didn't quite have the registration convention. Now, the gap that you see now in the later years, and it's interesting because the one thing that's really important to understand is the graphs we give you isn't, I launched a satellite today and you got the information today. You will have the information, so the launch figures that you see there is the information of when the object was launched. When you see the figure of the object registered, you may find that in 2021, I registered an object that was launched in 2020 because of the delays in when the submissions are received. I have member states that register very quickly after a launch. We have member states that are cyclical every month or every 2 months. I have member states who register once a year. So all of these patterns are different from member state to member state. So when you have a member state who registers, who does have a few objects that it launches every year, their registration documents get received almost at the end of the year for the entire year. And then I get a whole slew of registrations at the same time. So it's never one-to-one. The biggest problem that we have in terms of registration, in terms of trying to narrow that gap, is that the number of satellites being launched, the speed by which the number of new satellites are being launched, especially the Constellations, far outweighs the quickness of when a member state registers. So if, for example, OneWeb or Starlink launches 3 or 4 times in a month, that gap goes boom in just a few days, and then over the next few weeks, then it narrows again. So That's what is driving the gap between registration and launches at the moment, is the volume of satellites that are going up one shot.
Excellent. Now, Major, do we have time for another one of these questions? Would you like to pose another question to Tertia? Because I know that this is a very interesting topic for a lot of folks out there.
Yes.
You're generating a lot of
So
interest here,
many-
Tertia.
Yes, so many questions, so little time. We could have like one more question. So
well, I could also you could also, Michael, send us the
yeah.
questions, or we can always submit them and just reply to them later, or in writing or something like that.
Okay.
That could be so kind.
One more orally, because I think everybody wants to hear your views.
Yeah, I know.
Okay.
I'm gonna choose Jaime Corona's question. Hello, everyone. How does the register work for rockets in the case of Blue Origin, SpaceX, or another that had a re-entry mode, recovery of all parts of the object that land back on Earth? Is there something special that has been incorporated into the register?
Wow, you've got me on that one. No. I do have member states who do register the upper stages of the rockets. I don't actually know what's happening with the returning rockets. I expect that if they are returning, they're not being registered because they're being reused. So they're coming back, going back up. So they're only registering the objects that are staying into outer space. But that is a question I can ask Bobby. I'll mention his name. Bobby is the register person. He has an incredible amount of information. And whenever you reach out to us, I'll probably connect you with Bobby. Let me ask Bobby on the specificity of, for example, the SpaceX reusables. I'm trying to think back to the shuttles, whether they were being registered. I know for the space station elements, parts of the components are registered. But again, every member state has a different practice in terms of specific types of components that they register and don't register. I would find out and see if I have any information that could clarify this question a bit better for you.
So always so fascinating. There's so many particularities in the registration practice of states and how it's developed over time, how we are constantly dealing with, a interesting dialogue with states about these things, and trying to refine this for the benefit of us all. And now we are seeing the development of a new phase with these large and mega constellations, which is changing a lot of our activities and how we're approaching things. And we have a lot of these good questions, but Major, with your permission and your guidance, I guess we're going to go on to our next. What do you think?
Yeah. Yeah, so many questions. It was such an interesting talk. But since we have, like time limits, we will be introducing our next guest. It's Veronique Glot from the International Telecommunication Union, who will be speaking about the frequency allocations and avoidance of interference with space activities. So Veronique, the floor is yours.
Thank you, and good morning to everybody. I will share my screen and start the presentation. So we will start. Can you see my screen?
We can't see it just yet.
Perfect, thank you.
No, we can't. We don't see it.
Sorry.
We see you.
You see me. Sorry. So I'll try again.
Yeah.
Okay, I think I haven't clicked share. Is it okay now?
Yes, we see it now. Thank you.
Perfect, thank you. We start by looking at the importance of the regulation of the radio spectrum and the orbits before introducing the ITU and the role of the radio regulations. Then I will present you the main steps to submit a satellite network filing at the ITU before ending with the trends and challenges of these regulations. Oops, sorry. Why do we need regulations for the radio frequency spectrum and orbits? When we have a project in space, we think we will have no limits. However, satellites must communicate with the Earth and use the radio spectrum from an orbital location. There are two limited natural resources. They must be shared efficiently among all the needs of various radio services. It's from broadcasting to the internet to radio astronomy or Earth observation. As frequencies and orbits are used globally on the planet, beam directions can affect the operation of other antennas and create multiple risks of interference during operations of the services. And we know that in space, it is better to anticipate the risks. After the law and physics, now let us look at three specificities of activities in space today to understand how the radio regulations answer the question to ensure operation free of signal interference. First, space has a global impact. Then a treaty ratified by governments brings international recognition and stability. Secondly, space is not really big enough for all activities forever. There is a need to maximize the possibilities of use. So as a solution, the radio regulation proposes a process for allocating and coordinating the two natural resources, the spectrum and the orbits. It is also interesting to note that these two natural resources have the particularity, unlike water or air, of not being degraded by use. And finally, space is risky for investment. It is reassuring to have, before operation, the possibility of resolving the risk of signal interference and getting international recognition through the ITU frequency registration. Thus, the radio regulations provide a solution for operating a signal free from interference. And indeed, space is large enough for all operations only through effective cooperation and elaborated international regulations. How do the ITU and the radio regulations work? In the ITU Constitution, two articles are fundamental. The Article 1, it states that ITU shall effect allocation of bands of the radio frequency spectrum, the allotment of radio frequencies, and the registration of radio frequency assignment, and for space services of any associated orbital position in the geostationary satellite orbit or of any associated characteristic of satellites in other orbits, in order to avoid harmful interference between radio stations of different countries. And there is also the Article 44. It states that member states shall endeavor to limit the number of frequencies and the spectrum used to the minimum essential to provide a satisfactory manner the necessary services, and that the limited natural resources must be used rationally, efficiently, and economically so that countries may have equitable access to those orbits and frequencies. These fundamentals lay the foundations for a sustainable approach in space. What about the ITU? The ITU is the United Nations Specialized Agency for ICTs. Within the ITU, the communications sector called ITUR is responsible for the allocation of frequency band to radio services and for the proper functioning of procedures plan and operational measures. All this while respecting the principles for spectrum and orbits utilizations. The ITUR brings together delegates from member states, private sectors, and academia. The ITU instruments are its constitution, convention, and the International Evolutive Treaty, the radio regulations, together with its rule of procedure and recommendations issued by the ITUR. At the headquarters in Geneva, Switzerland, where I am today, The staff of the Radio Communication Bureau provides the secretariat of the ITUR sector and the radio regulations. As we have seen, the goal of the radio regulation is to ensure efficient and equitable sharing of spectrum and orbits. However, the space environment is constantly evolving with new technologies to be combined with existing ones. So the mechanism for decision-making is the World Radio Communication Conferences, which are the conclusion of a technical preparation by ITUR study groups during the 4 years between two conferences. This period of time is long enough to ensure full compatibility and short enough also to allow for the new activities in space. All stakeholders can participate together in the study of the agenda. So member states, member of private sector and academia. So consequently, the result is a stable amendment of the radio regulations, decided by consensus by the ITUR member states. The staff of the ITU Radio Communication Bureau process the satellite network filing submitted by national administrations in accordance with the radio regulations. So we will see now the main steps of this process. To control interference, the radio regulations have 5 mechanisms. So first, the frequency allocation, which allows the separation of different services. There are currently 40 different services. Secondly, the power limits, which protect terrestrial and space services by calculating PFD, RP, EPFD. The third one is the coordination. It is when operations are in the same portion of the spectrum and the previous limits in a second point are respected, but the coordination mechanism between operators needs to be done to eliminate any risk of interference. And once those 3 first mechanisms are completed, the fourth mechanism is a registration in the Master International Frequency Register, which provides international recognitions for the right to use the Semitic spectrum and orbit for the satellite network. Then the international monitoring system is the last mechanism to ensure control of interference once the satellite is in operation. Now let's look at the steps of what we call filing at ITU. So to prepare a submission to ITU, the first step is to identify the service area on Earth and its corresponding ITU region or regions, as well as a radio service and the optimal frequency band. With these 3 information and the type of network to be operated, so a geostationary or non-geostationary, you can refer to the table of frequency allocation to identify the provisions and processes to follow in the radio regulations. Here you can see the paper version of this table, but the ITU has developed tools to navigate automatically from a provision to another one. Then there are 2 approaches called coordination, non-plan approach, or space plans approach. The coordination approach on the left images on this slide is on a first-come, first-served basis. But as public parking, it can be full on popular sections, and the coordination process difficult for new satellites projects. On the other hand, the a priori space plans, on the right images of this slide, constitute reserved access to a geostationary location for future use by all ITU member states. The right to use the almost equivalent of a private space lot is acquired through a planning process at a World Radio Communication Conference. This plan approach gives priority to equitable access to space only in part of the BSS and FSS bands. It is similar to a semi-private parking. It does not optimize the use of the GSO when member states do not use their reserved slots because they remain empty. The process of filing for non-planned notices at ITU consists of two main phases, what we call the coordination phase, in which the Bureau examines the notice of the satellite network submitted in accordance with the radio regulations and publishes the result of the coordination requirements with other previously submitted networks. Then, after the phase of negotiations and adjustment of the parameters of the satellite project to eliminate risk of interference, it is the notification phase. The Bureau checks the final characteristic submitted and records the satellite network in the Master International Frequency Register. This process must be completed within a maximum of 7 years to avoid the unnecessary protection of projects not brought into use. And the satellite can be launched and operated with the international recognition to use the radio spectrum and the associated orbit. The other process is the process of filing for space plan notices at ITU. It consists of three main phases, this one. So either the administration uses the plan parameters already coordinated, and the satellite network will be notified and registered through a fast procedure, or the administration will apply some modifications to the parameters, and then the equivalent of the coordination phase is applied, in which the Bureau examines the compatibility of the notice of the satellite network submitted in accordance with the radio regulations. And once the satellite is compatible, it is entering the so-called list of assignments. Then it is the notifications phase. The Bureau checks detailed final characteristics submitted and records the satellite network in the Master International Frequency Register. And the satellite can be launched and operated with the international recognitions to use the radio spectrum and the associated orbits. So the space a priori plan remains always protected, whether there is a satellite operating or not. Now an example of plans. So for Chile and the Americas regions, it is the ITU Region 2. So the broadcasting satellite service plan for GSO is in the bands 12-17 GHz, and the fixed satellite service plan for GSO is in bands 6-4 GHz and 13-10-11 GHz. The provisions are available in the appendices 30, 30A, and 30B of the Book 2 of the radio regulations, and we have the BR software and online applications to assist you to proceed with the filing and examination if needed. Now let's talk more about the coordination process in practice. So the ITU is known for ensuring the coordinated use of the space resources, the radio spectrum and the orbits. However, as the number of satellite filings increases, it is recommended to plan carefully in advance when to submit a filing within the regulatory deadlines to allow sufficient time for coordination with other operators. The ad hoc study and scaling of the satellite system is also essential to reduce technical challenge and unnecessary coordination and to ensure compatibility operation with other satellite systems. I would like also to talk about the concept of called first come, first served. It is not as definitive or black and white as it seems, thanks to the provisions added to allow operation to newcomers under conditions, and to provide technical justifications for existing systems contesting the newcomers. With this approach, which is more a filing date of reception approach, satellite system may not be in use during the coordination phase, and a speculative approach of future use is required. But with the application of provision 13.6, ensuring the monitoring of the actual use of satellites, there is no longer a paper satellite program to manage, as in the past. This is good news to improve the coordination process. So indeed, we can remind that the radio regulations procedure is a balance between the rights and obligations of both the incumbent administration and the new administration. No administration obtains any particular priority as a result of being the first to start an ITU procedure. We have seen how to anticipate the risk of interference before the satellite is in operation. Now, what happens if the interference occurs during satellite operation? So the regulation has provided for the provisions of Article 15 an interference infringement of the constitutions of radio regulation. It states that all stations are forbidden to carry out unnecessary transmissions or the transmissions of superfluous signals, or the transmission of false or misleading signal, or the transmission of signals without identifications. The station which is causing harmful interference should immediately eliminate this harmful interference. This assumes a legal link between the transmit station and the administration under the jurisdiction of which it is placed. So it is a concept of national license. It's under Article 18 of the radio regulations. Before concluding, let's look at the trends and challenges of the space sector for radio regulations. During past years, the private investors and new technologies are allowing new needs and usage of the spectrum orbit couple. For example, the large constellations since 2015, the small satellites, the short duration missions, and coming exploration of the moon, of Mars, or of asteroid resources. So ITU and the radio regulations may be challenged by actors not coming from the telecom world or from the national administrations. However, it remains essential and unique mechanism to prevent signal interference, to ensure a stable environment and equitable sharing of global natural resources. Key points to remember from this presentation is that radio frequency spectrum and associated orbits are two natural limited resources to be globally shared and regulated. The legal framework is the ITU Constitution, the Convention, the radio regulations, its rules of procedures, and ITU recommendations. The goals are in the ITU Constitution, Article 44, to avoid harmful interference, to ensure efficient, rational, equitable, and economical use. And the radio regulations contains 5 complementary mechanisms. So allocation, coordination, power limits, registration, monitoring to ensure interference-free operation. The radio regulation constantly being improved to adapt to the needs of operators and the technologies. And the next World Radio Communication Conference will be in 2023. So please don't hesitate to contact us at ITU if you have any question. We'll be always happy to assist you. So thank you. Over to you.
Oh, thank you very much, Veronique. It's always interesting to hear the work of the ITU when it comes to frequency allocations. And there is a question here for you, and I have also a thought about this, but from your perspective, is there such a concept of space allocations for nations, such as a quote, space real estate? Is this being complied, or whoever gets there first has the right to own that location in space? And maybe this also has to do with the first come, first serve. So maybe you could give your perspective a bit on that.
So if you, there's a space plans, if you want. So every nation, so ITU member state, so every country has 193 has an allocated place on the geostationary orbit for usage of on national territory of some broadcasting or fixed satellite services. What is related to the first come, first serve is there's no concern about the nation for those one. So there's some provision to moderate, to give some priority in some bands to some newcomers, but there's no list of nation being having priority or not priority. I hope I got the...
Right. I think you touched on it, because the GSO is a unique place. It is a very unique orbit. that where those states right directly below those should have some kind of priority, let's say, to get their objects there in the geostationary orbit. But for the others, there is it's done through coordination and through working together with states and the users in order to define the frequency allocation for those users. Is that correct?
Yes. So it's just a question of coordinating. If the coordination of the signal is past the limits and there's I mean, coordination agreement with the administration of the other networks that could be affected, then it's okay.
Yeah. Very good. And let's see, here we have another one. You're very unique. It's not clear to me if the two approaches presented are actual approaches you adopt or use in the planning approach to avoid the effects of the first come, first serve. Would you please clarify this a bit further?
Yeah. So this is, yeah, okay. Planning. So you remember the image with the parking lots. That's why it's give information. The planning approach is not for every frequency and every orbit, as we just repeated. And there's also some free space for those parking lots somehow, so space and frequency usage. And then it's first come, first served. But first come, first serve with some obligation. You cannot say, I'm here, I'm blocking arrival on usage of other newcomers. If you want to say, okay, no, the other one cannot come close to me because they will interfere me, you have to prove technically that you will be interfered. So it's not just, I'm here, I don't move. You have to prove that you will move. And there's no other planning for every band and otherwise. So it's more, and it's more a combination of some justification and obligations to keep along the right, and the newcomers can always come and find solutions. So it's really coordination and negotiation. There's always possibility of modifying parameters to allow newcomers to enter the game.
Right, absolutely. And just a final thought on this. It says, could the ITU and UNOSA be models for intergovernmental space organization for coordination? And I'll pass this over to you for a second, Veronique. But from my perspective, well, we're always happy to work with the ITU and coordinate as much as we can. And we have a long-standing history together and working together, because the ITU and Veronique sees the satellite filings for frequency allocation long before we see the registration of those eventual satellites once they're in orbit. So Veronique sees it at the beginning, we see it sort of at the end of the journey somehow, and we really like that. So we have our own coordination mechanisms, but we're coordinating with the same member states at the end. One in the beginning and we at the end. So were your thoughts on that, Veronique?
Yeah, no, true. We have and we have two registers. I mean, ONUSA has a register of objects, ITU has a register of the networks and the spectrum usage. And of course, the dream, what would be great, is to have a connection in between those two registers, to have an even better coordination in between our two entities.
Absolutely, and we're going to hear more from Hamza on various other ideas in registries coming as well. And thank you so much again, Veronique, and Major, back to you. Thank you.
Thank you. Bye bye.
Back over to you, Major. Thank you. It's over to you, Major.
Thank you, Michael. I can't hear you.
Oh,
quite
I'm sorry.
well, but I believe you. Yeah. Oh, but you pass it over to me, right?
Yes. Yes, absolutely. Thank you again.
Great.
Yes.
Great. Thank you. So thank you, Veronique, for your great presentation. It raises so many interesting topics. Now we are going to hear about the update on the Space Assets Protocol of the Cape Town Convention on International Interest in Mobile Assets, Perspectives of the Space Economy by Mr. Hamza Hamid from Unidroid. So, Mr. Hamza, the floor is yours.
Thank you very much, Major Fabri, and a big thanks to the government of Chile and to the UN for their kind invitation to me and to UNIDWA to present here. I'll just try to share my screen now. There we go. Can you confirm that you can see my screen? Can you see my screen?
Yes, we see it. Thank you.
Excellent. So thank you very much, Major. Thank you to the government of Chile, and thank you to the United Nations Office for Aerospace Affairs for organizing this this excellent conference and for inviting UNIDWA to make a presentation on the space protocol of the Cape Town Convention. I think this presentation comes at an excellent time in this panel, keeping in mind that we've already talked about the registration mechanisms of the UN and the ITU and how they work, and now I'll try to talk about more of a economic element and a financial element to the registration of security rights and interests within space assets. As Major kindly noted, I'm Hamza. I work for UNIDWA, which is an intergovernmental organization headquartered in Rome in Italy with 63 member states, Chile being one of them. And today I'll be talking a little about the Space Protocol of the Cape Town Convention, which is an international instrument or treaty designed to promote the use of asset-based financing in the space industry. Throughout the presentation, I'll be going into how the Space Protocol and the registry to be established under the Space Protocol will help and facilitate space traffic management, and I'd be happy to welcome any questions at the end. So the starting point for the Cape Town Convention and its protocols was a growing global need for financing, and particularly for private capital in the acquisition of high-value mobile equipment. This was particularly evident in the space, in the aviation sector, where there was an exponential growth of air traffic in the aviation industry, with a large amount of growth coming from the private sector and aviation industry, and the aviation industry needing to attract a significant amount of more private capital and private support rather than continuing to rely on public financing. There were also various positive externalities of the acquisition of new equipment, such as greater safety in air travel, environmental regulations, noise rules, etc. At the same time, there were significant legal obstacles in the use of asset-based financing and leasing, particularly for cross-border transactions, as there were no uniform law instruments available that gave assurances to financiers and creditors involved in the aviation industry of the protection of their security rights in these assets that they'd be financing. Traditional conflicts of law approaches were generally not applicable or best suited to moving assets or assets that cross borders, and legal systems varied in their approach to recognition of security interests, especially for the process of enforcement and in the remedies available thereafter. So, at UNIDWA, we are experts in the area of commercial law and secure transactions law, and so this problem was presented to our governing council in the early 1990s, and the solution that was proposed was a uniform legal regime created by treaty that would facilitate the financing and leasing of certain types of high-value, uniquely identifiable mobile equipment to be used in specific sectors. The four sectors that were outlined right at the beginning were the aviation industry, the rail industry, the space industry, and the mining, agriculture, and construction sectors. And thus was born, after several years of intense negotiations, the Cape Town Convention in 2001. The Cape Town Convention is a two-tier treaty system whereby there is a head treaty, which is the Cape Town Convention, or the Convention on International Interest in Mobile Equipment itself, which was adopted in 2001. And then there are various protocols to this convention that apply the rules of the convention to specific industries and tailor some of the provisions to the needs of that specific industry. The aircraft protocol of the Cape Town Convention was adopted in close coordination with the International Civil Aviation Organization in 2001 alongside the convention. This was followed by the adoption of the Luxembourg Rail Protocol to the Cape Town Convention in close coordination with the Intergovernmental Organization for Carriage by Rail, OTIF. In 2012, we adopted the Space Protocol of the Cape Town Convention after several years of debate and discussion, and then there were various contributions to this process by intergovernmental organizations, including the United Nations Office for Aerospace Affairs and the ITU. And in 2019, we adopted the most latest version of the Cape Town Convention, which was its protocol on mining, agriculture, and construction equipment. Today, I'll be talking a lot more about the Space Protocol. The main objectives of the Cape Town Convention and its protocols are sixfold. One, they seek to facilitate the acquisition and financing of economically important items of mobile equipment by providing for the creation of an international interest, which will be recognized in all contracting states. Two, they seek to provide the creditor or financier in any secure transactions arrangement with a range of basic default and insolvency related remedies, and where there is evidence of a default, a means of obtaining speedy relief pending final determination of its claims on its merits. Three, to establish an electronic international registry for the registration of international interests, which will give notice of their existence to third parties and enable the creditor to preserve its priority against subsequently registered interests and against unregistered interests and creditors in the debtor's insolvency. Four, to ensure that through the relevant protocol that the needs of a particular industry sector are met. 5, to grant contracting states a degree of flexibility in adhering to the international regime by allowing, to a well-defined and limited extent, policy choices through declarations while preserving the basic uniformity of the legal regime. And 6, and finally, by these means, to give intending creditors greater confidence in their decision to grant credit, thereby enhancing the credit rating of equipment receivables and reducing borrowing costs and credit insurance premiums to the advantage of all interested and involved parties in the space sector. Since its adoption in 2001, the Cape Town Convention has repeatedly been regarded as the most successful commercial law treaty ever adopted. This is evidenced by the treaty's implementation in all parts of the world. At present, the Cape Town Convention itself has 83 contracting states and has also been approved by the European Union. Furthermore, the success of the Cape Town Convention can be measured in numbers, whereby if you look at the amount of registrations taking place in the international registry for the aircraft protocol, you can see that the aircraft protocol of the Cape Town Convention has significantly increased the amount of money flowing into the aviation sector and has facilitated billions of dollars worth of transactions in the aviation market. The aircraft protocol at present has 80 contracting states, as well as the signature of the European Union. In the international registry, there have now been more than 1.3 million registrations against more than 500,000 aircraft objects, the estimated value of which is more than 650 billion US dollars. Additionally, economic assessments of other protocols of the Cape Town Convention have shown potential for delivering the same levels, if not more, of benefits to countries all around the world. I have some numbers on the screen here which talk about the economic benefits of the mining, agriculture, and construction protocol, which suggests that this protocol is expected to have a positive impact of 23 billion on GDP in developing countries and 7 billion in developed countries every year, for a total impact of more than 30 billion USD per year in the mining, agriculture, or across the mining, agriculture, and construction sectors. Moving to space now and digging into the space protocol, I don't think after the presentation that was made by the UN on this issue that it needs to be said, but the space industry is growing at a tremendous speed. In 2019, the size of the global space economy was more than 360 billion, which was divided across various sectors, and it is expected that by 2040, this will be more than 1 trillion. Additionally, various studies have shown that the number of satellites being launched on average per year has increased significantly. One study showed that between 2019 and 2028, the average number of satellites being launched per year would be 990. And if I look at some of the numbers that were presented by Natalicia at the beginning of this panel, this could be significantly higher. Additionally, these satellites may be used for various purposes, and then the types of uses for these satellites has also changed, with Earth observation now taking up the major chunk of where these satellites are being used. What's more interesting, particularly from UNIDWA's perspective and the perspective of the space protocol, is that the amount of private investment flowing into the space sector has significantly increased over the years. These charts showcase how private sector investment in the space sector has continued to grow since 2001 and is at an all-time high right now. The charts also show the various different vehicles through which private sector financing flows into the space sector. And then it's quite evident that right now, a majority of private sector funding that's flowing into the space sector is by means of seed funding, venture capital, and some by private equity, with other mechanisms taking up a lower share of the market for private investments. These types of numbers are incredibly common in industries that are experiencing a startup boom, or industries where there are a lot of small companies that are entering into play right now. However, all of these types of financing are not sustainable for long-term exploration of outer space and for the long-term growth of these companies, as eventually, once they've moved past that seed funding venture capital stage, they will be in the market to get access to more traditional types of financing, including things such as debt financing and asset-based financing, which is what the Space Protocol seeks to promote. This map shows that financing in the space sector, private financing in the space sector, is now coming from all parts of the world rather than being concentrated only in a few countries. This showcases that private space companies and private space financing is becoming more and more popular all throughout the world. Thinking about the space economy and thinking about companies in the space economy, it's important to look at how these are being financed. So, besides receiving government funding and grants or relying upon the financial capacity of their founders, private entities in the space sector typically rely upon either equity finance, unsecured lending, or project finance, primarily through debt financing, to attract investment and to fund their operations. Traditionally, the space industry had comprised of AAA rated companies which had relatively easy access to capital due to their financial stability and creditworthiness. As such, they had large amounts of access to equity funding, to unsecured lending, and to project finance. Very often, space companies often relied on obtaining either equity or project finance from lenders at an acceptable rate by keeping their on-ground assets or their balance sheets as collateral. They have often also been financed by government grants, as governments like to support their space companies. However, if you look at the new space sector, this is no longer true, whereby new space companies are much smaller, much leaner, and more innovative, with relatively lower credit ratings and lower amount of assets on ground. As such, access to credit has been regarded by the European Banking Institute and European Investment Bank as a major challenge to the growth of the new space sector, and a challenge that most developing countries need to address in order to make sure that private space sectors can continue to grow. And this is exactly what the Space Protocol of the Cape Town Convention seeks to do. Whenever a bank or a financier is looking to lend money to a company, whether that be in the space sector or any other sector, on a secure transactions law model, which is a model where the financier is lending against an asset. There are three main factors that creditors must look at very closely before making the decision to grant credit or deciding the cost of that credit. One is the amount of the loan. Two is the value of collateral, which can be recovered net any costs of recovery. And three is the degree of certainty over loan repayments. The Space Protocol of the Cape Town Convention greatly impacts the value of collateral, which can be recovered net any costs of recovery, because it makes recovery of a space asset, in the case of an insolvency of a debtor, much easier. This slide showcases the scope of the Space Protocol of the Cape Town Convention, whereby it applies to all spacecraft or parts of spacecraft or payloads or parts of payloads, as long as they are deemed to be individually financeable or bankable by the Space Registry regulations. Once an asset is considered to be under the scope of the Space Protocol, parties can create international interest in the form of security agreements, title reservation agreements, or leasing agreements over these assets, which can then be protected through a registration in the International Registry for Space Objects. Once registered, these registrations take priority over subsequently registered interests in that same asset or over unregistered interests in the case of a debtor's insolvency. So what this does is that once there is a bank or a creditor that has an interest in a satellite or a space object, in the case that the operator of that satellite or space object goes bankrupt, the bank or the financier will be able to access that space object and ensure that it has priority access over that space object over any other parties that may have competing financial rights or interests within the same object. The Space Protocol adapts the Cape Town Convention to the specific needs of financiers in the space sector, such that it has various different provisions for space sector specific applications. This includes provisions for the assignability of debtors' rights, provisions on tracking, telemetry, and control, an exception for public services, which is quite important, particularly in developing countries, clauses relating to salvage rights for insurers, provisions on physically linked assets, mechanisms for identification of space assets, and many others. The one that I will look at in this presentation, and then I'll move towards my conclusion, is the insolvency mechanism that's built into the Space Protocol. The drafters of the Space Protocol took into account the physical impossibility of repossession in outer space and tried to address this issue with using two separate means. One is by building into the Space Protocol provisions that allow for the assignability of debtors' rights. So essentially, in the case a debtor becomes bankrupt, a creditor may have access to the revenue streams that the debtor is collecting on a particular space object, thereby resulting in the payment of the creditor's rights in that space object and allowing the creditor to recover its investment. Secondly, and perhaps more importantly, the Space Protocol provides for repossession on the basis of tracking, telemetry, and control, which is such that in the case a debtor becomes bankrupt, a creditor has the rights to access or take over the tracking, telemetry, and control information of a particular satellite, thereby allowing the creditor to then sell that satellite onto a secondary market and recovering its investment. This is particularly important when you think of issues such as the launch of large constellations, or also issues relating to space traffic management, whereby we find that there are companies now that are launching hundreds of satellites into space and then often running into financial difficulties. For example, OneWeb was a good case study to examine, whereby they already had hundreds of satellites in space and then ran into financial difficulties, whereby it was hard to find another buyer for the company as a whole. What the Space Protocol would provide for is access to individual satellites in a constellation like that, allowing for companies in financial difficulty to remove individual satellites off their balance sheets based on an asset-based approach and allow competing financiers to enter in and acquire those satellites, thereby satisfying the needs of that main creditor and also ensuring sustainability in outer space. There are several types of financial transactions that the Space Protocol promotes. These include the types shown on this slide. On the right, you can see an example of a typical sale and leaseback arrangement, whereas on the left, you can see an example of a very typical leasing arrangement. These are all types of transactions that the Space Protocol greatly facilitates by ensuring that the riskiness of the extension of credit is reduced and that the amount loaned to the debtor will be paid even if the debtor becomes insolvent. The Space Protocol greatly promotes these types of transactions. Additionally, there are several benefits that the Space Protocol has, particularly to new space financing. By providing for the creation of a new level of risk for financiers and the creation of a uniform regulatory regime for the recognition and protection of security interests in space assets, it is ensured that issues of conflicts of law and differing insolvency remedies are avoided and that creditors can lend to developing markets with greater confidence. This ensures greater space sustainability and more access to credit for the space industry, particularly in developing countries where capital and finance is hard to come by in the space sector. For companies in particular, the Space Protocol allows companies to leverage their assets rather than having to lend against their balance sheets or give up rights or shares within their company. This is beneficial for the company in terms of its long-term sustainability and also beneficial for the creditor because it allows the creditor to only have an obligation to monitor the asset rather than the whole company. Additionally, future creditors can also very easily search the online international registry and make sure that a particular asset is free of competing rights or interests in the case that it's looking to acquire one. To conclude, many new space companies are unable to get access to credit in typical forms of space financing, especially at later stages in their development when venture capital or seed funding is no longer an option. As such, the ability to leverage their assets in exchange for favorable lending terms may provide to be a very, very important tool to allow companies to get more access to capital. This also allows companies to use their technology to secure financing rather than having to divest their stocks. It's important to note at this stage that the existence of the option to go for asset-based financing does not deter a company from going for other types of financing, such as unsecured lending or project financing. It's simply an added option. Furthermore, the international registry that would be established under the Space Protocol of the Cape Town Convention would be completely independent of registration requirements and the registration practices of the UN or the ITU, because the register under the Space Protocol would simply be a register that records international interests in space assets. It is an asset-based register that is that is recording or giving notice to the world of the existence of financial or economic rights within a space asset in the case that competing creditors or financiers want to invest in a space object, or in the case that a debtor becomes insolvent or faces financial difficulties and the creditor needs access to their asset. To provide for the continued growth of the space sector and to reach this 1.1 trillion threshold that the space sector is expected to reach by 2040, access to credit and capital to be invested in the space sector is incredibly important, and the Space Protocol promotes this. Right now, the Space Protocol is the only treaty which relates to commercial law and secure transactions law in the space sector, and is a good option for states that are looking to increase the amount of private capital being channeled into the space industry. At present, UNIDROIT continues to negotiate closely with governments, international organizations, experts, and academia to increase the understanding of asset-based financing in the space industry, particularly with the rise of new technologies such as in-orbit servicing, in-orbit manufacturing, and in-orbit transfers of space objects, as asset-based financing becomes a more palatable option as these technologies become more accessible. We think at UNIDROIT that ratification by states and greater involvement by industry will allow the Space Protocol to start benefiting the global space economy and start delivering the types of benefits that the Aircraft Protocol of the Cape Town Convention has already delivered, and also play an important role in facilitating more space traffic management and increasing access to credit within the space sector. So with that, I'll stop, and I'd be very happy to welcome questions as part of this session, or you're very welcome to contact me by email or online or anywhere. So thank you very much, and I'll stop sharing my slides now.
Oh, thank you very much, Hamza. That's very interesting. And yes, we have a question for you. Hello, what could you point out about the insurance policies involved with ensuring the launch and the defined orbit?
Well, thank you very much for that question. I think there are several parts to that question. It's important to understand what the scope of the space protocol is, such that it only applies to assets that are in space or designed to be in space. So while it does apply to reusable launch vehicles, it does not necessarily apply to rockets per se, as those are objects that are never designed to permanently be to be in space generally. In terms of insurance policies, when you think of asset financing, insurance is a separate subject, and the Space Protocol recognizes that. And as such, there are particular articles in the Space Protocol on salvage rights for insurers. And the Space Protocol confirms that should there be an insurance policy on a space asset, which allows for insurers to have salvage rights, those would take priority over any other rights that exist in that particular space asset. So I'll stop there. The Space Protocol does not interfere with the rights of insurers in any way or form.
Oh, thank you very much. Thank you very much, Hamza. And so one kind of a general sort of question before we before I make a final comment on this, but do we need a common law ground for space commercialization? Would you see that this plays a role in finding that common ground?
So thank you, Mark, for that excellent question. It's good to hear from you again. We see, at UNISWA, we believe that uniform law and uniform commercial law in particular plays an incredibly important role in promoting more cross-border finance and cross-border business in any sector. We've seen the importance of uniform law in the aviation sector, and we're starting to see the importance in other sectors as well. And a common law ground, particularly when it comes to secure transactions or conflicts of law, gives a significant amount of confidence to investors in all parts of the world when making lending decisions in different parts of the world. And we find that that common ground increases the availability of credit and increases and greatly decreases the cost at which that credit is extended. As such, allowing for more business to take place and more commerce to take place across borders. So we've been working on facilitating these types of initiatives for decades, and we're very hopeful that similar results can be achieved in the space sector by unifying secure transactions law. Yeah, thanks.
Very good, very good. And just one final one. In countries where the protocol is not enforced, like in Chile, do you know what the main source of financing is for private sector activities? You touched a little bit on this, but maybe you can say a few more words. Thanks.
So thank you for that question. And yes, it's true that we've been working with Chile for a long time with, so Chile is one of those countries which has signed the aircraft protocol and the Cape Town Convention and is still working on its domestic process to ratify both the treaties. And we're very hopeful that that process will continue to move in the right direction. In terms of the main source of financing for private space projects, particularly in Chile, I would not have that information. However, we do find that in most developing countries, a majority of space companies are financed through government grants and public sector funding rather than private sector funding, simply because of the large amount of risk associated with the space sector. Public grants and government institutions want to support the development of space science and space technology, and there are lots of benefits that space technology can bring to the population of these countries and the UN's office does a great job in highlighting those. And as such, public institutions do support these projects quite a lot. In terms of private financing, you often find venture capital from different parts of the world coming in. So you will find big banks like SoftBank or export-import banks as well sometimes that invest in these high-risk sectors, but that's a lot less compared to venture capital and public funding.
Wow, thank you so much, Hamza, for your informative presentation. And this truly is the next level of where we can see space activities going. This offers a huge opportunity for the private sector, for entities that would not have access to financing to actually achieve that, to then launch their projects and really take the space economy to the next level. It really is a fascinating area, and it offers a lot of room, especially when looking towards the next step of all these space activities, including, like you mentioned, the on-orbit servicing, the manufacturing, the assembly in outer space. All of those items that are created will need to have some financing behind them. This allows for that, as well as onward to other celestial bodies, all of the space resource equipment that will be used and needed in the coming decades. This would be the primary vehicle for most of that. I mean, this is very, very interesting stuff. And with that, I know we have to move on. And thank you so much again, Hamza. Please, back over to you, Major. Thanks.
Thank you. And thank you, Hamza. Financing is always such a big issue when you want to create real opportunities for everyone to participate. So it was very insightful, and it's great to know that this type of regulations are in action. So thank you very much. And now we present our next speaker, Bernhard Schmidt-Ted, Chair of the WVD 3E LSC, who's going to speak on bringing the benefits of space to all countries, a guidance document on the legal framework for space activities, and the guidelines for the long-term sustainability of other space activities. So, Mr. Bernhard, the floor is yours.
Thank you, Christina. Thank you, UNOSA and the Government of Chile for inviting me, and for you for the kind introduction. And now I try to introduce the slides. Do you see something?
We see you, and now you're projecting.
Okay. So, the subject is bringing the benefits of space to all countries, and we focus on the guidance document and the LTS guidelines. And the starting point for all those reflection about LTS, the regulatory frameworks, the guidance document, and space benefits for all is the Unispace plus 50 resolution, reiterating that all countries, irrespective of their degree of economic and scientific development, are participants in, contributors and beneficiaries of the exploration and peaceful use of outer space. Here we have in this Unispace plus 50 resolutions linked to LTS, the role of the committee, and international cooperation in order to contribute to realizing a shared vision for the future in the exploration and use of outer space. The Unispace plus 50 resolution reaffirms the unique role of the committee as a platform of international cooperation for the developing of international space law, for fostering the dialogue among spacefaring and emerging space nations, for promoting the increased involvement of all countries in space activities, including, and that's especially a subject today, through capacity building initiatives, taking into account the Space 2030 agenda. How does different subjects fit together? We had the Unispace Plus 50 process for more than 3 years, resulting in the resolution of 2018. UNUSA had then an outcome with the Space Law for New Actors project, which is also mentioned in the Space 2030 agenda. The thematic priority 2, legal regime of outer space and global space governance, current and future perspectives, resulted in the guidance document, and the LTS guidelines had been adopted in 2019. In TP2, we had, as a result of the work plan, this guidance document, which was finalized last year. And now we are in a process of implementation of all those different elements, and especially of the Space 2030 agenda. Let's now have a look on the guidance document itself. The mandate for the guidance document comes from the session of 2016 of COPORS. The object of the guidance document is to give states essential information on the state of affairs of the legal regime governing outer space, including relevant instrument applied through national regulatory frameworks and international mechanisms for cooperation. This guidance document should also help states wishing to become a party to the 5 United Nations treaties. And in the working method of this mandate, we see already the link to the LTS subject, since the coordination with the working group of LTS was explicitly mentioned. The significance of the guidance document. It's the increasing number of space actors, which is the background for this initiative. And in order to have an uniform understanding of the UN space treaties under the condition of this growing number of space actors, is necessary to have a flow of information on best practice and of the state of the art. The guidance document is in line with the objectives of the thematic priority 2 of Unispace Plus 50 to promote the universality of the 5 UN treaties, to assess the state of affairs of these treaties and their relationship with other relevant international instruments, and to analyze the effectiveness of the legal regime of outer space. The purpose and the rationale of the guidance document. It is intended to assist states in acceding to the space treaty. And governments need to be aware of the potential implication of space activities that are carried on under their jurisdiction. Sometimes universities, private actors enter in space activities in a country which had not yet space activities, and it's not always under the visibility of the state itself. There are today so many participations and possibilities to enter in a rideshare mission and to have a small object launched in outer space. This guidance document serves as a capacity building instrument, and it has a potential of cooperation in space matters among parties to the 5 UN Space Treaty. And it's at the same time a document for possible outreach activities. Let's have a look on the structure of the guidance document. There are 5 chapters. It's the introduction and overview, then the elements to assess when considering becoming party to the UN space treaties. The third chapter refers to the work done by the legal subcommittee and the enormous amount of legal documents already realized and relevant for the operation of space activities. The fourth chapter is then focused on the development of national space policy, strategy, and regulatory frameworks. This is also an interesting aspect, since in a number of countries there are 2 types of legislation: a space policy act or document on the one hand side, and then the national space legislation in fulfilling the obligations under Article 6 of the Outer Space Treaty, meaning licensing and supervision of national space activities. And the fifth chapter then focus on elements for consideration in international cooperation, since there we have also a long-standing practice of cooperation agreements between the different spacefaring nations. The character and content, the guidance document is by nature voluntary, a voluntary instrument, and it gives an overview over the legal regime of outer space. Here, 4 elements I want to underline: the interlinkage to substantive areas of work in the legal subcommittee, the soft law instruments developed in the legal subcommittee, the concept of the launching state, the registration practice, the working group we had on national space legislation, and on international mechanisms for cooperation. There are specific operative considerations concerning licensing, authorization procedures, registration procedures, space debris mitigation, operation of small satellites. And then the elements for consideration in the international cooperation and elements for consideration for the development of national space policies and strategies. Let's now switch to the LTS guidelines, the second part of our subject. Those LTS guidelines have 4 main chapters: one about policy and regulatory framework of space activity, space operation, safety of space operation as the second major chapter, then international cooperation, capacity building, and awareness building, and finally, scientific and technical research and development. Under the chapter C, we have the guidelines about promotion and facilitation of international cooperation, sharing experience about LTS, and activities to develop new procedures. Then promotion and support of capacity building and awareness raising of space activities. I just picked up 2 examples from Chapter A and B. Chapter A on the policy and regulatory framework for space activities. Here are the guidelines 1 and 3. In guideline 1, it said states should consider not only existing space project and activities, but also, to the extent practical, the potential development of their national space sector and envisaged appropriately timely regulation in order to avoid legal lacunae. And then in 3, states should ensure that the management of an entity that conducts outer space activities establish structures and procedures for planning and conducting space activities in a manner that supports the objective of the LTS guidelines. Appropriate measures to be taken by management in this regard should include a commitment on the highest level. As a result, this shows that there is a demand for a proactive regulation and requirements for the management of space operators. This is a quite interesting point, looking proactive in the future of the space sector. And under B, safety of space operations, we have this guideline concerning design and operation of space objects, some specific elements to increase the trackability, which is important for safety, and on a precise determination of their position in orbit. This shows that an interaction between the public side and the private operator is absolutely necessary. And also in the further aspect, conducting pre-launch conjunction assessment, which then has a relation to the adequate licensing procedure of this mission or intended launch. So there are enhanced requirements for mission preparation. As an overall picture, we can say that there is a matrix between the concrete legal points, the abstract rules in the treaties, and the LTS guidelines proposing a lot of operational elements. And we had this word matrix already under TP2, under the thematic priority 2, the clusters we developed. And it's an important point to realize that these LTS guidelines have specific relations to concrete articles of the space treaties, and that they make them operational. It's a second layer under the treaties. And we have, when we look at the chapter 1 of the LTS guidelines context, also paragraphs underlining the relation to the sustainable development goals and capacity building mechanisms. And the overall point is the continuous institutionalized dialogue on the implementation of the guidelines. With this, I would like to demonstrate how the purpose and place of the guidelines and the guidance document fit in the overall picture of the treaty. We have the 5 UN treaties, we have the soft law instruments, the guidelines, the resolutions, and the purpose of the guidance document is to raise awareness about the overall picture of this substance we have on the legal framework. But at the same time, it's the national implementation which is necessary to reach a good global governance and an implementation of the legal regime. The guidance document in its general context, there are links to the Space 2030 agenda, and with this to space diplomacy and the regulatory frameworks, to the safeguard of the basic principles as contained in the Outer Space Treaty, and a link to the further development of space law. The guidance document has the function to integrate newcomers, to give an oversight over a quite complex legal regime and its application, and to offer guidance and connected support activities. We have also, under the Space 2030 agenda, the subject of the relation to the Sustainable Development Goals, and here the number 16 relates to peace, justice, and strong institution, and to promote the rule of law at the national and international level fits under this SDG 16, and awareness raising and capacity building fits under this aspect of SDG 16. Yes, as a concluding slide, what is the perspective in the legal subcommittee? We have now a very rich and comprehensive agenda at the legal subcommittee which we can use. We have the working group on the status and application of the 5 UN treaties. We concluded with the guidance document a major step, and I think it's now the point to develop a new work plan going in the direction of 2030 and to support the 2030 agenda and the implementation of LTS with supporting elements. And then we have now the multi-year work plan for the working group on legal aspects of space resource activities, and in addition, a number of single issues for a discussion like space debris mitigation and remediation measures, non-legally binding instruments, space traffic management, and aspects of small satellite activities. With this, I will conclude my presentations, and if you have any questions, I am open to respond. Thank you for your kind attention.
Thank you, Professor Schmidthead. Absolutely, and you, of course, are the chair of the working group on the status and application of the 5 United Nations treaties on outer space, and so you have you've developed this with the support of the member states, you've developed this guidance document. And now we have a question, and it says, in which way should we implement the Outer Space Treaty and its obligations in our national space laws? So I think that speaks to exactly your work. So maybe another couple of words on that would be great. Thank you.
Yeah, thank you for your question. And you know that it's sometimes difficult to get the message through on the national level. The first point is that we really need this national space legislation in the spacefaring countries. But we have now reached a second step, and this is the implementation of the guidelines and the other instruments. And if we see it from a national perspective, it means that we have now the focus on the quite operational level, which makes it concrete. If a country starts with development of a national space act, there are many examples, and the act as such is perhaps not so complicated. But then on the operational side, you need ordinances to implement the, let's say, general rules. And all these instruments we have now with the LTS guidelines, with the overview and the guidance documents, that help to formulate this operational layer, this elements which could also be on the national enactment, the ordinance to implement the National Space Act. And I mentioned this institutionalized dialogue, and for me this is important to have living documents. We see it also with ITU, where we have on the one hand side the convention, the fixed legal framework, on the other side living documents updated from time to time, which makes the implementation of the Space Act and the licensing process then up to date to the changing conditions.
Exactly. That's exactly it. I mean, we have these obligations. We have the treaties. They have various provisions, but in many ways, it's the national governments to implement them, implement those obligations and duties of the treaties into their national space legislation. It requires an understanding from the governments, and that's exactly what this guidance document is supposed to facilitate, is to help them understand how those duties and obligations can work and how they can implement those in their national space legislation and really operationalize the treaties themselves for their purposes, for their benefit, what they see in their jurisdiction. So it's incredibly helpful, and this it brings together, this guidance document brings together all of the legal work that has been done over the years in the legal subcommittee, and really brings it into one place. So it's an incredible resource. And again, I would like to thank you very much for sharing that and sharing your experience and for working with you for all of these years on this. And it's been a real pleasure. And thank you very much. And with that, I'll hand over to our distinguished moderator, the good kind Major. And thank you so much again.
Thank you. So, thank you very much, Mr. Schmidt-Ted. It was a great presentation. Legal framework is so important. And I mean, if you can synthesize it, it's so much easier for governments to, introduce it to their internal legislations. So now we go on a break. So it's a 10-minute break. So we should be back at 11:15. So we can continue with the presentations, okay? See you in 10 minutes.
Thank you.
Sir, I think you need to stop sharing your screen, but that's great. Thank you again.
Hello, everyone. We're back. Can you see me? Can you hear me?
Yes. Can hear you perfectly.
Great. Great. So now it's my pleasure to introduce our next speaker. That's almost our neighbor from Brazil. We're going to introduce now Olavo Bittencourt from Universidad Católica de Santos, Unisantos, Brazil, who's gonna present on the question of the definition and delimitation of outer space, perspectives on governance and space traffic management. Olavo, the floor is yours.
Thank you very much, Major Cristina Fabri. Muchas gracias por la invitación. I'd like to thank all our colleagues at UNUSA and the Government of Chile for organizing such an important event that's so relevant for researchers and updated researches on space law and policy, and also quite relevant to outreach activities down here in South America and in Latin America. So I'd like to congratulate you all for such an amazing event that's going to cover so much ground in just 3 days. And it's, of course, a great honor being here, participating in this discussion among some of the greatest names that we have in space line policy. And I hope to be able to meet you all soon in person, eventually, my dear Michael, in Vienna. And hopefully I'll be able to return to Chile pretty soon. I really miss your beautiful country, Major Cristina, especially the lake region. I love it there, and I hope to be able to return pretty soon. The topic that I'm going to cover today during the next few minutes is one that I've been doing a lot of research for quite a long time, and it's about the definition and the limitation of outer space. And it remains one of the oldest open questions that we have in space law, and for a good reason. It's not only a really complicated legal issue, but also involves quite a lot of political calculation, and it's also very complex from the scientific point of view, since the Earth's atmosphere has no sharp edge. But it's a topic that deserves to be revisited nowadays, and it's gained quite a lot of momentum in international discussions due to multiple factors that we're going to be covering, but most importantly, due to the evolution of technology and the growth of the global space economy. So during the next 15 to 20 minutes, I'll try to cover as much ground as possible, focusing on the main points of contention in relation to definition and delimitation of outer space, while also addressing questions related to global governance and space traffic management. Of course, my greatest intention here today is to have some exchanging with each one of you in the audience, to know what to think about this relevant issue, and most importantly, to try to figure it out alternatives towards the solution to this issue. Because after so many decades, we still have not been able to find a solution to the question of the definition, delimitation of outer space multilaterally. And it's important to figure out alternatives and also to consider why such a decision is relevant nowadays. Okay, so thanks again for the invitation. I believe you can see my screen. I'm going to start going through the slides now. Okay, so first, let's start from the beginning. It's really important to start from the beginning. Space law has a clear geographical scope because it constitutes the rules governing the humankind's activities in a certain domain, outer space. And there's a legal frontier that has not been delimited up to now between territorial airspace which is under national control and jurisdiction, and outer space, where no claim of sovereignty is authorized by international law. The problem is that even though we have here a legal problem, two distinct legal systems that somehow are over each other and not specifically overlapping each other, and we do not have a clear delimitation of the frontier between those two legal systems, up to this moment, even after decades of debate, there has not been a common universal solution accorded universally, internationally, especially at the United Nations. But nowadays, we're seeing a push towards some sort of definition solution. And why is that? Because first of all, technology is evolving pretty fast, and we're seeing a lot of activity going on, especially in near space, in low Earth orbit. We're also seeing the technology, the differences between aeronautics and astronautics blurring with time. And we're talking about aerospace activities, suborbital flights, including suborbital flights related to space tourism. We're seeing an increased relevance of the global space economy, and we've seen throughout the past few presentations how many new space objects have been launched into orbit and how much private participation is behind it. And of course, we also must take into account questions related to the long-term sustainability of outer space, as Professor Schmidt considered just a few minutes ago, addressing problematics related to space traffic management and space situational awareness. So those issues are pushing forward the international community to discuss alternatives related to the definition and delimitation of outer space. Of course, this is a sensitive issue, but technology is advancing, the economy is advancing, and we cannot sustain this legal vacuum for much longer. Why this is such a sensitive issue, especially from the political point of view? Because whenever we're talking about the definition and delimitation of outer space, we are talking about the vertical limit to the state sovereignty, the vertical limit to the territorial extension of each and every nation on Earth. So the vertical limit of state sovereignty is a really complicated and touchy issue, especially because it revolves around a fundamental axiom of international law, that is the territorial principle. So what we have in classic international law, and I believe every one of you already know it by heart, is that sovereignty is focused on a certain area. Sovereignty is the exclusive independent power of a state in relation to a population in a certain area. So sovereignty has always a geographical scope as well. Complete state jurisdiction is circumscribed to the national territory. That's another fundamental principle of classic international law. And we do have the Lotus case from 1927, where the Permanent Court of International Justice said that a state may not exercise its power in any form in the territory of another state. And also, when we dive into the UN Charter, Article 2, Paragraph 4, it's pretty clear in there. All member states shall refrain from the threat or use of force against the territorial integrity or political independence of any state. So when we're talking about definition delimitation of outer space, we're talking about the delimitation of the vertical limit of the national territory of each and every nation. And we are considering the possibility that some space activities may somehow violate the territorial integrity of underlying states. So this is really a complicated political issue. There is simply too much at stake. But we must take lessons from experience. And history has showed us that whenever we do not have clearly provided international borders, whenever we have disputes in relation to frontiers, the risk of international disputes rise considerably. And we are seeing this throughout the globe right now. So it's always important to recall a quote from Lord Curzon. He wrote in the beginning of the 20th century, but what he said back then, it's still relevant today, when he said that frontiers are indeed the razor's edge on which hung suspended the modern issues of war and peace. And what we're talking about when we discuss the vertical limit of state sovereignty, when we talk the limitation of outer space, is we're talking about frontiers of each and every nation around the globe. So this is not a simple matter. The problem is that we do have a frontier here between two different legal systems, air law and space law. We know that it's there, but not exactly where. And why is that? Revisiting the law. When we consult and review the Outer Space Treaty, Articles 1 and 2, we see that outer space constitutes a domain to which all nations have access, but to which none has the right to claim sovereignty. So it's basically an example of a global commons. On the other hand, when we review the Chicago Convention of 1944, we can see that states have complete and exclusive sovereignty over the airspace above its territory. So we have here two immiscible legal systems, like water and oil, as far as state sovereignty is concerned. Since space law and air law are based in two different legal regimes when we address the question of state sovereignty. Therefore, what we have here is a legal problem, which leads to a very contradictory reality, a very complicated reality, because right now we can say and state that outer space constitutes the vertical frontier of national territories, which, even though finite, extend themselves above the surface of the Earth up to an undetermined altitude. So, once again, we have a legal problem that is also a sensitive political issue and a complicated scientific question. How can we address such an issue? How can we find solutions, especially universal solutions that may be applicable to each and every nation around the globe? Multilateral debates in relation to definition delimitation of outer space have been going for a while, for a long while. And mostly they have been focused on the work of the legal subcommittee of the UN COPUS. Back there, ever since the maiden flight of the Sputnik 1 back in 1957, we had discussions related to the repercussions of the consequences of the so-called Sputnik legal precedent. Because once Sputnik reached orbit and its flight path passed over the territory of so many nations around the globe, and those nations have not protested violation of their territorial integrity, a legal principle of the fundamental legal principle of space law was constituted, that space objects in orbit do not violate the sovereign integrity of underlying states. So ever since Sputnik 1, discussions regarding definition delimitation of outer space have been going on at the United Nations. But most importantly, at UNCOPUS, which was created as a permanent committee back in 1959. At UNCOPUS, since 1966, we have a topic in the agenda of the legal subcommittee regarding matters related to the definition and delimitation of outer space. The introduction of this topic was back in 1966 by a French proposal, and it has remained in the agenda with some modifications in wording ever since, but without a solution. And we even have a working group on the definition delimitation of outer space at the legal subcommittee, which was long presided by my mentor in space law, Professor José Monserrat Filho, which I'd like to pay tribute now, because he was the one who suggested me to dive into this complicated matter more than 10 years ago. And at this working group, so many solutions and questions and possibilities have been considered, so many alternatives addressed, but we have not been able to achieve consensus. The decision-making procedure at Unicopus is based on consensus. And right now, it's becoming increasingly more difficult to build consensus at the Unicopus in relation to some sensitive issues, and most importantly, regarding the definition, the limitation of outer space. And why is that? Because basically, two chains of thought, two theories and perspectives have built themselves up throughout the years. One covering the functionalists, which do not support a clear definition of the limitation of outer space, and spatialists, which are positive towards some sort of solution on that regard. Those two groups, they have changed over time, and middle ground positions have often been presented. But even though a lot of discussion has been going on throughout the many sessions of the Unicopus ever since, we have not been able to achieve consensus toward a solution. That creates a deadlock. And deadlock hampers any sort of agreement, even regarding the possibility of withdrawing the topic from the agenda of the legal subcommittee. So it's a major conundrum, major dilemma. We cannot find a way out of this maze. Okay? So let's try to figure it out a little bit more and take a deeper look into the perspectives of those two chains of thought, two perspectives. The functionalists, they are gonna have reasoning that somehow can be summarized as stating that outer space does not need to be delimited, or even it's impossible to provide a sort of delimitation of outer space by so many different legal or even scientific reasons. The justification for not finding a solution to the problem right now is also connected to the reasoning that we have no problems up to now to justify such a legislative effort. The idea is that basically air law and space law have been able to live with each other for so long without any major problematic and any major legal issue. So why focus all our attention and our precious time in trying to find a solution to a non-existent problem? That's the perspective of many of the functionalists at the Unicopus. So how can we identify the legal regime applicable to a certain activity? The connection would be with the nature of said activity, with the purpose and actions connected to that activity. So would have to identify the nature of the activity, not where it effectively takes place. If we have a space activity, it would be ruled by space law, no matter where the space object is. That creates some sort of complications because, first of all, we do not have a clear delimitation of what a space activity is. There are some major differences of opinion in relation to that, even nowadays. And also, the functionalist approach may lead to a complicated consequence. Why is that? Because based on the functionalist rationale, arguably, space launches and re-entries would never disrespect the territorial integrity of foreign nations, since passage rights would always be granted. Is that an abuse of rights? Is that a reasonable position? Especially considering that the discussion of passage rights for space launches is still a very contentious issue. Also, we must take into account what's the reasoning behind the functionalist approach. To many nations that follow that reasoning, there are other considerations that must be weighed on. especially when we're talking about major military powers or major spacefaring nations, because the lack of regulation may grant to those nations a lot more flexibility of operations. And just quoting Thomas Gengay, he said that you can't break a law that does not exist. So eventually, the lack of provision regarding the limitation of outer space may be beneficial to a major spacefaring nation and a major military power, giving to that nation a greater latitude for action, especially in low Earth orbit. But the spatialists, they follow a different perspective. Why is that? Because they considered, based on so many different ideas, that we need to provide some sort of delimitation of the frontier between airspace and outer space, because that is legally relevant. It provides greater legal certainty, and it's something that should be considered, addressed, and negotiated by the many nations at the UNICOPS. But those specialist nations, they have proposed many different alternatives for that delimitation. And throughout the many years, we have considerations of different legal and technical criteria to provide the delimitation. Just to mention you the most relevant ones: effective control, that's based on basically military power and capacity of operations; atmospheric limit, the highest segment of the atmospheric layer that could be somehow identified by science; the lowest orbital perigee, the segment of the orbital path that crosses closer to the Earth. Both of those alternatives have complications based on science. And why is that? Because basically the Earth's atmosphere has no sharp edge. The Earth's atmosphere is an ocean of air, which expands and contracts with time due to so many natural causes, including solar activity and the position of the moon, for instance. We also had discussions in relation to mesospace, a segment that would be between airspace and outer space under a different legal regime. And of course, arbitrary delimitation, just a clear legal standard that could provide the delimitation. But here again, we have a difficult calculation, because if we set a delimitation too low, that could undermine territorial integrity, leading to very complicated political discussions. But if we set the delimitation too high, relevant orbital positions may be affected. So to strike a balance, to provide a clear delimitation of this frontier is really complicated, especially since science does not provide a specific number that could be used to identify the maximum altitude of the Earth's atmosphere. We can, based on a study of the many proposals and positions that have been presented at UNICOPS, we can safely say that most COPUS member states are spatialists, numerically speaking, but there is still no consensus in relation to a single standard for a solution. So, what's the consequence of that? Without a universal solution to this problem, in the absence of any multilateral regulation, states are authorized to provide unilaterally the delimitation of their own national territory and also of their national airspace. And consequently, they are authorized to even specify the domain which is regulated by their national space laws. And based on a comparative approach, just reviewing the many national legislations that are somehow connected to the discussion of definition delimitation of outer space, I can say to you all that there's clearly a lack of legislative pattern. I just included here some few examples. Of course, there's so many more, and read so much about it in other instances in my book as well. But just to give you a different perspective, some nations are providing the limitation based on the arbitrary number of 100 kilometers, for instance, Kazakhstan and Denmark. Other nations are more focused on navigable airspace, as Belarus. Other nations are combining the approach with some scientific perspectives, such as Austria, which establishes that the place at which aircraft can no longer operate by aerodynamic lift, but only according to Kepler's laws, which I find it amazing to mention Kepler in a legislation. So I always love to quote this Austrian legislation. And we do have here in Latin America, situation of Ecuador and also Colombia in some ways that claim some sort of sovereign rights regarding segments of the geostationary orbit above their national territory. What we can see is this: we do not have a universal delimitation. So, since with time, more and more states are establishing and negotiating and enacting national space laws that somehow have a specific domain referred to, or some sort of delimitation of the scope of activity, we can even foresee a complex scenario in the next coming days, because eventually, if each and every nation provides unilaterally the delimitation of its airspace and consequently the delimitation of outer space, the border between national airspace and outer space may differ from one country to the other. That can provide quite a lot of difficulties to development of sustainable space activities, also lead to complicated issues related to military use of outer space, and possibly leading to complications to the development of the global space economy. Concluding my presentation, I'm already over 20 minutes here. I just would like to make reference to a related topic that's also connected to the discussion definition delimitation of outer space, which is space traffic management. And when we're talking about space traffic management, basically, we're talking about means and rules to access, conduct activities in and return from outer space safely, sustainably, and securely. So based on that perspective, it's pretty clear that space traffic management mechanisms would benefit from the proper identification of where outer space begins. And also we must take into account that the Earth's orbital space is really a hot commodity and also a finite resource. And we've seen that and we heard about that during the previous presentations. So this is really a domain that is subjected to specific dangers, and also a domain that's really relevant nowadays to humanity. You know, our world of today relies heavily on orbital infrastructure. So international cooperation is required for us to find a way to bridge those differences, to strike a balance between the perspectives from the functionalist nations and the spatialist nations, and also supporting responsible behaviors in outer space. So on that regard, to conclude, I believe it's time for us to focus on this issue seriously, supporting somehow the limitation of the frontier between airspace and outer space through multilateral negotiations, trying to accomplish a universal delimitation and solution to this issue, taking into account space traffic management mechanism requirements, space security in general, but also addressing the problem of passage rights for launching and re-entry of space objects. Okay, so, but I would love to know more about your opinions in relation to this interesting topic. So I'd like to pass the word back to Major Christina and Michael, and ask you all if you got any questions in relation to what I've just presented. Thanks again.
Oh, Oliver, thank you so much for recounting this incredible issue. This issue of definition delimitation has been, as you well put, it's been discussed for so many years, and of course, you know, we have a wealth of documents on our website that are reproduced and made available at every legal subcommittee meeting. And just to let you know, our online responses go back at least 10 or 15 years. We have those documents online. We have a historical summary that was first started in 2002. That covers all the years before, and then that was updated in 2020. So it is a, and that was done by the secretary of the working group on definition delimitation, who worked so closely with Professor Montserrat Filo, and it is an incredible topic that continues to this day. And I would just like to add, as from my observations of this issue and this topic, that it really has to do a lot with legal philosophy. This is at the core of this issue, where we see that there is an approach that is taken by many of the common law countries, the United States, the United Kingdom, this approach, Canadians, the Australians, where it is that is in a lot of ways dysfunctional approach, but that is rooted in the manner in which these countries view their laws and have made laws. And so it is almost like this idea of the chicken before the egg. In many common law countries, it is, you have rights to do things and only prohibited by the states, by the regulator, let's say. Whereas regulation in many other countries, civil law countries, it is a permissive activity of regulation, where only activities that are permitted by law are acceptable and legal. So these two different approaches have come to a head in this particular topic that's been discussed, like you said, since the 1960s. And it's an amazing viewpoint about the way that we all work together as an international community, as countries working together to try to understand how we think about laws, how we think about what we are doing. So this, of course, is going to be the basis in a way of our coming view of other types of regulation, of other types of space activities in the future, where different legal philosophies are going to play a huge role, especially in the space resources area, where it becomes issues of property law and property rights, which harkens back even to the Romans' ideas of property, carried forward all the way through what we have now seen for over 2,000 years. So these ideas of legal philosophy are incredibly interesting, and they come in space law, which is to the heavens and beyond. So it's really an amazing opportunity to see this as well. And I want to thank you again for your contribution and for giving your views on this incredible topic during our Space Law Conference. Thank you. Over to you, Major. Thank you so much.
And if I may say, Michael, thanks again for your compliments and your kind words. And I agree with you. Studying definition delimitation of outer space allows us to dive into philosophy of law and how law develops, how law is conceived, not only by nations, but by us as people. So it's really interesting, and also makes a connection to what you just said, the ontological nature of outer space. So it's really a rich topic that from the legal point of view is quite relevant to be studied, and such a thrill to getting through it. And of course, I'd like to mention, and you properly refer to the great work done by UNUSA in relation to compiling the different perspectives, alternatives, and suggestions to solve this complicated issue. So many proposals have been forwarded, and those two documents that you mentioned, where UNUSA compiled the many alternatives, they are really invaluable to us academic researchers. So it's important to thank you all for the hard work doing that. I know it's not easy to do it.
No, it's a really interesting, it's a real legacy that we have, and it's such an interesting sort of thing where we, as the Office for Outer Space Affairs, we sort of transcend this past into this present, what we have, and then to be looking into the future, and we really get to see something that is quite unique in all of the law. It's very unique. So. And with that, thank you so much. Back to you, Major Fabri. Thank you. Yes, I think you might be, your connection might be stalled a bit, Major Fabri. Yes. Maybe come in again. Ah, yes, we see you. Over to you, Major Fabry. Thank you.
Yeah, I didn't catch that.
Oh, back over to it's to you. Thank you again. On to our
Okay,
next.
so I'll introduce our next speaker. We look at the stars now, and we present Andrew Williams from ESO. He's going to present on dark and quiet skies, impact of space activities on terrestrial astronomical observations, governance perspectives. So, Mr. Williams, the floor is yours.
Yes, hello, Mr. Williams, Dr. Williams. We can't hear you. I think you are on mute, sir. We see your presentation, but we can't see or hear you.
He's in mute.
Yes, I'm requesting an unmute. Yes.
Okay, can you now hear me?
Yes, we can hear you. And if you would be so kind, put your camera on so for the interpreters. It's great. Ah, yes. Thank you, sir. Thank you.
Okay, well, thank you very much for that introduction. So good afternoon and good morning, everyone. So on behalf of ESO, I'm really pleased to be invited to talk on what is one of the most significant policy issues for astronomy in the recent times. So thank you very much for this invitation. I am responsible for external relations at the European Southern Observatory, and I am the representative in COPUS. And this subject of the impact of space activities on astronomy is something that I have been dealing with for the past few years. So just a few words about ESO. We are a treaty-based intergovernmental organization. Our mission is focused on developing and operating world-leading astronomical observatories and fostering cooperation in astronomy. We operate a suite of observatories in 3 separate sites in the Atacama Desert in Chile, serving thousands of scientists around the world to make amazing discoveries about our universe. We have now 16 member states in Europe and a strategic partnership with Australia. And the pooled resources of these countries and the collaboration with our host country of Chile is allowing us to achieve global leadership in ground-based astronomy, which is really exemplified by our latest project to build the extremely large telescope, which will be the largest optical telescope in the world at its first light later this decade. So for what reason do we go to Chile with our observatories? Well, firstly, Chile has a strong astronomy ecosystem. There are many observatories in the country, and Chile is really a leader in providing strong institutional support for astronomy, support of government support of government policies, and for this, we are very grateful. However, the key reason is that the Atacama Desert is really an amazing natural laboratory. Its unique combination of dry air, low cloud coverage, low light pollution, and atmospheric stability means that in the Atacama Desert region, you can find really exceptional and beautiful dark skies. Now, these days, with light pollution from cities, you don't get to see a sky like this as shown in the picture. And I really like this image, which was taken by an Iranian-American astrophotographer, Babak Tafreshi, reaching out and trying to touch the stars. And whenever I see a sky like this, it's amazing and it's magnificent, but it's also poignant or almost a bit painful in a way, because I know that I can never travel there to these stars. They're too far away. We're seeing light from thousands or even millions of years past. So the only way that we can travel there is by building giant telescopes and doing astronomy. And on that note, we come to the subject of the talk. So I'm going to explain to you about some of the impacts of space activities on astronomy, mainly focusing on the topic of satellite constellations. And I'll go a little bit into the detail about the impact here, because it's such a new subject, and it's a subject that I think the space law and policy community will have to deal with in the coming years. So it's important that we have the understanding. I'll then explain about what we've done over the past few years to respond to this issue, and then I'll close with some thoughts on how this issue can be governed in the future. So first, to understand the impact. Well, the astronomy community knew about satellites and have dealt with the occasional lost image, but we were really taken by surprise when the first batch of SpaceX's Starlinks were launched back in May 2019. And this was the results you see here, and this immediately gives you a qualitative sense of the problem. Now, the large image here and the top right image show the situation immediately after the launch of the Starlinks, which is a particular stage of operations when they are closely spaced together and they're bright. They're also low in the sky. And soon they disperse and they raise in altitude. So actually, the more common impact in the future will be the bottom right image here. So a single streak or maybe a few streaks in the telescope. However, the more satellites in the sky, obviously, the more likely it is that we will have these streaks in the images. In some cases, it's not relevant for the science objective, but in many other cases, it requires extra processing or retaking of images. And time on these leading astronomical telescopes is usually very limited, very competitive, and very costly. Now, it's not only ground-based facilities that are affected. So here you see some images from the Hubble Space Telescope, which is in low Earth orbit at about 560 kilometers of altitude. And generally, it's looking away from Earth, and thus it's looking through the many layers of low Earth orbit, which are now populated by thousands of satellites. And recent calculations now show that the Hubble Space Telescope has about a 6% chance of seeing a satellite trail in an image, and this is now. And of course, this is only going to increase in the future as the number of satellites increases. So in the past year, the astronomy community has done a lot of work to understand the impacts. The first step is to build a model and to simulate what the future scenario will be. So for this, we needed to know the future set of satellites in low Earth orbit in the coming years. And as we've heard over the past 2 days of this conference, I mean, this is uncertain to some extent. So we are tending to take the most likely constellations and looking at numbers between 50 to 100,000 satellites. So what do these simulations tell us? Well, for a representative sample, for example, of 80,000 satellites in low Earth orbit, there will be about 5,000 satellites above the horizon at Paranal. That's where our observatories are located. So 5,000 satellites at any given time throughout the night. They tend to appear low in the sky, and they're concentrated in the region just above the horizon. They're mainly illuminated at twilight hours, so just after sunset or just before sunrise, and depending on the season. Although in the short nights in the summer, we can still have them visible all night. And it's also important to say that at higher or lower latitudes of Earth, so for example, closer to the Arctic Circle, they are more visible for longer in the night. So what does this mean for the character of the pristine night sky? Well, for the casual observer going on the outskirts of a city, so the chart here is showing Brussels, the red line at the bottom shows what you could see. So maybe a few or less 100 bright objects during twilight hours, if you know where to look. But if you go to a dark site, away from light pollution, away from the obstructive view of buildings, the impacts will probably be much more noticeable. The sky will have more visible moving objects, and particularly at twilight and low on the horizon. Now, for the impacts on professional optical astronomy, well, this isn't a straightforward analysis. It depends on a number of factors: the type of telescope, the type of observation, the type of satellite. In many cases, you can just retake an image or reschedule it, but in some cases you can't, and the science is just lost. So this represents the case for the top right image here. So the bright satellite has saturated the detector, and this particular image is lost. Now, we've done the analysis, and we found that for our flagship facilities, the Very Large Telescope and the forthcoming Extremely Large Telescope, the problem is manageable in that only a few % of frames will be affected. And this is mainly because our telescopes are very narrow field, so we're seeing a tiny portion of the sky, and actually we don't do so many observations at twilight. So it's manageable, but is this percentage loss acceptable? Now, for the wide field facilities that see a large portion of the sky, or for facilities that need to do their science at twilight, such as studies of solar system bodies and asteroids, this is a real problem. There is a US project, for example, the Vera Rubin Observatory, which will have the world's largest wide field camera on an 8-meter telescope, and they are facing many images ruined, and almost every single image will have a satellite trail. So they are now working really hard to figure out how to deal with the situation. So here is a panoramic simulation which gives a visual impression for you of the density of the future satellites as viewed from the ground. And I think it's kind of helpful to understand sort of what we're facing in the future. So the blue line here in the middle, this is the geostationary arc. So the satellites that appear as they are in a fixed position from the observer on Earth. And you can see, looking at the bottom, how they're concentrated towards the horizon. And now it says at the top here in the text that these are visible satellites, but what it means is that they are satellites that are just above the horizon. So you won't be able to see all these satellites with your eyes because they're not all illuminated by the sun. However, they are always there, and let's assume that most of them are transmitting in the radio spectrum. And this brings us to the next category of impacts, which is on radio astronomy. So if you look at the chart here on the top left, so these yellow bands here are showing that radio astronomy does have some protected bands under the ITU regulations, although it's only about 2% of the radio spectrum. But of course, science still happens outside these protected bands. We need to observe outside them. So this blue bar just above here is showing the frequency range that the new square kilometer array observatory will be able to see. So the SKA just became an intergovernmental organization a few months ago. And, how can radio observatories do this? How can they expect to be able to observe outside of the protected bands? Well, they find a remote area and they negotiate with the local government to protect the entire frequency range within that radio quiet zone. And this has happened in South Africa and Australia. So this is shown by the orange bar here. And that's where the square kilometer array is being constructed in the coming decades. So this means, no radio masts, no TVs, no mobile phones of certain types, within this radio quiet zone. But the change that's now occurring is that with the satellite constellations, as we've seen, there will be thousands of them overhead at any time, and they will be transmitting. So you can't hide in a ground-based radio quiet zone. Another issue is that while the satellites are tiny points, they have radio beams that can actually be quite large on the Earth. So if you look at this image here at the bottom, this is showing the beam footprints of various internet satellite constellations on Earth. So this is the eastern seaboard of the United States. So, there's several hundred kilometers at least here size. And radio observatories are extremely sensitive and can detect even the signal leakage and the electronic noise from spacecraft. So the bottom line issue here is that the current system of frequency management, coupled with the local and kind of ground-based nature of radio quiet zones, is gradually becoming insufficient to protect radio astronomy. We will increasingly rely on agreements directly with companies or more complex arrangements with government regulators, which is a new challenge. So what have we been doing about these issues over the past few years? So the first step has been to just reach out to the companies and set up collaborations with the industry. This has been very productive, and we really have learned a lot on both sides. So SpaceX were one of the early leaders in this area, and they've made some concrete steps and made some physical changes to the satellites, and this is much appreciated. They tested experimental dark coatings, and they deployed a sun shield, a so-called visor sat. And we've observed these new satellites, and they have achieved a reduction in brightness, although there's still some work to be done on that front. And now Amazon Kuiper are also testing a sun shield concept on some satellites that will be launched later this year. And then we have OneWeb, who are doing an observational campaign with some astronomers of their satellites to inform the future design of their phase 2 constellation. So these steps are excellent, but in the long term, this isn't really a sustainable solution. We're relying on the goodwill of a few operators, and it's important to find a way to transmit the lessons that we're learning together to the broader community and to codify them some way. Now, in the past 2 years, the astronomy community has conducted a variety of studies to identify the issues, to understand mitigations. And I'd like to mention that COPUOS actually tasked the UN Office of Outer Space Affairs to work with the government of Spain and the International Astronomical Union to host a conference looking at this topic of dark and quiet skies. Now, as a result of the pandemic, this was split into 2 activities. So we had Dark and Quiet Skies 1, which looked at the technical aspect and established scientifically based guidelines and mitigations. And then we had Dark and Quiet Skies 2, which focused on the pathways to implement the mitigations and the recommendations. And I'd like to tell you about 2 important things that happened as a result of this work. So the first one is that the International Astronomical Union has established a new center to work on this issue, to coordinate the efforts of all the various stakeholders and produce and disseminate information and continue research on the topic. So we are now in the process of setting up this center in the coming months, and we'll be getting to work looking at increasing the collaboration with industry and with policymakers. The second important event was that in the 59th session of the Science and Technical Subcommittee of COPUOS in February this year, our recommendation for a new agenda item was accepted. This was based on a working paper which we submitted based on the results of the Dark and Quiet Skies work, and it focused on the impact on astronomy and on the feasibility of implementing the recommendations that we made. We had extensive interaction with industry in the lead up to this work. And in the end, we didn't propose specific regulatory frameworks, but suggested voluntary guidelines and ways to foster further collaborative actions. And, it's really heartening that we had Chile, Spain, and Slovakia as member states of COPUOS that endorsed the paper as co-signatories. And it was great also to hear the views of many COPUOS member states during the discussion, reaffirming that this is an important question in the overall topic of space sustainability. So this is good progress. So I will now finish my presentation with some thoughts on the governance, the future governance of this issue and how we can take it forward. So let's return to our friend here that's trying to touch the stars. And just to point out that underlying all of our efforts is the basic fact that no specific laws exist that govern the visual or the scientific use of the sky. Maybe it could be implied a little bit in Article 1 of the Outer Space Treaty, but there's a US law against obtrusive space advertising, but that's a very specific context. And of course, there are many local and national laws against light pollution, but these are mainly ground-based, and they don't say anything about light coming from space. Now, in the Dark and Quiet Skies 2 project, we looked at some of the interesting questions that you can raise from a legal and policy perspective about in the light of the growing number of space activities in low Earth orbit. So, are there international space law obligations to protect dark and quiet skies? Is space an environment? Does international environmental law apply to the space environment? How do we consider the aggregate effects? So rather than focusing on the the single point registration or licensing, how do we account for the accumulation of issues? And this is particularly relevant to astronomy. How do we deal with the heritage and the cultural sky traditions? Just think that it's only in the past 100 or 200 years, maybe, that humanity has not been able to see the sky as it is here in this picture. Now, I will leave it to the space law community to really consider all these issues and details, but I'd like to just close with a few thoughts. And just to mention, actually, looking to the future, we have to consider that the current low Earth orbit satellite constellations, are not the end of the problem, but really they're just the beginning. So all these projects shown here, they have the potential to provide great benefits on Earth, to increase space sustainability, such as this concept for passive deorbiting sails, which obviously you can see from the picture that it could be a very bright object. But in addition to raising questions for astronomy for the visual impact of the night sky, we really have to think about how we deal with these issues. So, question: Are our ambitions for constellations of tens of thousands of units, for large structures in space, for space-based solar power, and for new orbital space stations in low Earth orbit with multiple human presences, are these ambitions outpacing our rational abilities to regulate, to finance, and to ensure these projects in a sustainable and environmentally friendly manner? So, going back to astronomy then, what can we do? Well, the first point here is that we need to think of astronomy as a space activity. And of course, I'm very cognizant of the previous presenter who has sort of indicated that the understanding of what a space activity is not fully defined. And also some of this depends on the functionalist versus spatialist debate, which I don't want to go into, but just let's assume prima facie that astronomy is a space activity. And if you recall the criteria of Article 1 of the Outer Space Treaty, noting that it's not a later article, it's the first one, that there is freedom of exploration, there is freedom of use, and freedom of scientific investigation for the benefit of all humankind. So we see that astronomy is literally the use of outer space. In some cases, it takes place in outer space. So here we see at the top, the Hubble Space Telescope, providing us with amazing science for the past 30 years. And of course, there are many other space observatories out there. Astronomy from ground and from space is providing essential services to space missions, such as precision tracking of distant satellites, and also providing necessary and complementary scientific investigations for the exploration of outer space. So the bottom image here is the comet that the ESA Rosetta mission visited in 2014. And before the visit, it was extensively studied in astronomical terms, in scientific terms, by ground and space telescopes in order to support the scientific exploration of this body. And mentioning the benefit of humankind, well, the recently launched NASA DART mission, it's on its way to impact with an asteroid. This can't be done without an observing campaign from from astronomical facilities to put the results in context and to see if it actually worked. So, if astronomy is a space activity, we can then look at triggering the obligation, in Article 9, the cooperation and due regard, the avoidance of harmful interference through a consultation mechanism. We can think about the obligations in Article 11, the need to inform the Secretary General of the United Nations, as well as the international scientific community, of the nature and conduct and location of space activities. Now, I think it was said earlier that we haven't really seen this in practice, but this is something that we are now actively thinking about. So where can we go from here? And this is my closing thoughts. We're in the early stages. This is really a new problem for the space community to deal with. And I'd say that we're in the first stage here, the process of norm building. So here it's really important to encourage voluntary cooperation with industry. We need to build expertise. We need to understand what the solutions are and to learn. And this allows then us to create the normative expectation in the space industry that they have to consider astronomy, just like as has happened for space debris. I think it's also important to have a similar normative pressure on states, and in a way, their full acceptance of the responsibility under the Outer Space Treaty. So on the one hand, they're responsible for stimulating the space sector in their country, for regulating it and supervising it, and they should also be responsible for dealing with the negative externalities, or at least facilitating cooperation in this area. So the second pillar here of this way forward would be to develop some kind of non-binding codified guidelines and ratings. So initially these would be astronomy-led, but we also need the industry in there and the involvement of governments. And one idea would be to create some kind of rating or incentive scheme, taking the soon-to-be launched space sustainability rating as a potential example. And we understand that the development process of such a scheme is as important as the end result in terms of building understanding about the mitigations and future regulations. The third aspect here, the important role of international dialogue, which I hope will take place at the next STSC session next year under our new agenda points, which is fantastic. And at a lower level, we can support this with the new IAU Centre by providing expert views and hopefully the generation of some proposals and concepts. And finally, and I think the previous speakers have noted this extensively, that it's up to states to implement the intent of international space law. So we need future national policies to give the intent, and we need future national regulations on these matters. And if you ask the question, well, what should a future regulatory scheme achieve? It should prevent impacts before they occur. It should minimize disruption during operations of the thing being regulated, and it should ensure some mechanism of redress after the damages have occurred. So I think an initial simple starting point would be to include the requirement to consult with a national astronomy body as a condition for licensing. And in the future, we need really to elaborate more on the specific details of this, just as we see at the moment with the ongoing discussions about space traffic management and space debris. And on that note, I will close, and I'm very happy to take any questions. So thank you.
Dr. Williams, that was a very comprehensive presentation over some very interesting issues that really you actually hit the nail on the head with the current debate that we are facing. And this is where you are facing this in your work. And it is something we are also wrestling with as the international community, how to balance the scientific needs with the free exploration and use of outer space. Where do we draw those lines? How do we encourage this kind of, and if I may, space activity? This is, I mean, I would say the oldest space activity that we've had. Humanity looked to the heavens And it began with space activities, with observations of stars. And it has guided us through exploration of our own planet, and it has guided us in exploration into space and beyond. So this is incredibly crucial, how we handle this, and we see this the coming. We're going to see more satellites, more constellations, more desire for these uses, and we need to balance that with scientific needs. And it is incredible that and a wonderful opportunity that Chile has demonstrated and has shown their leadership in this area as well. Spain and Slovakia also, but with the massive amount of investments that are going on in Chile for the very large telescope, the extremely large telescope. These are incredible installations that cannot be replicated anywhere else. So Chile has a unique environment that must be used for this purpose. This is an excellent purpose for use of territory on Earth. With that, I really want to express that this is a definite topic of discussion that will go on for years. We are incredibly interested in following this. Major, do you have something to add from your perspective?
Oh, nothing. I mean, astrology is a huge issue for us, and we're very proud about it. So we try to keep our skies clear, and it's, if you ever have like the opportunity to visit, it's beautiful. So nothing else. Yes. I mean, it was a great presentation.
Absolutely. We have a question though. Maybe Nicholas, who's been following this issue very closely over the years, please.
I just want.
You have two. Yes.
Yeah. Before you take.
Wait, you have two things open. I think we're hearing an echo from you.
Okay. Take the questions and I will get back.
Okay. One question that we have for you, Dr. Williams. Are you working with governments to address light pollution in a complete way? What have you addressed? What you've stated here is about light pollution from satellites, but how do you deal with the light from cities that makes it difficult for citizens to see space and can appreciate the stars? Has work been done on this, having more intelligent cities, smart cities? I think this is an issue to be put in a work folder. So your thoughts on that, sir?
Yeah, so just to say, I mean, practically any major observatory, needs to be in a dark sky area. And, you see dark skies being now an aspect of tourism. So countries are encouraging this in a way. And as I said, there are many local laws and national regulations that are aiming to keep the sky dark and to try and deal with the aspect of light pollution, which not only interferes with astronomy but also interferes with our own health in many respects, and also can interfere with certain flora and fauna and wildlife. And there is a lot of work and a big community that is working on this subject. Now, what's interesting is that we're seeing the kind of intersection of these different spheres of government competency. So I'd say in general this topic is maybe dealt with a Ministry of Environment, or it's kind of delegated to local agencies, and this the issue of satellite constellations. This is dealt with a different set of agencies, and of course is a topic for international space law. And we've been thinking about how to try and bring these two areas together. So this is definitely work in progress.
Excellent, thank you. Yes, that is. Please, Nicholas, your thoughts.
I think I'm on now. And
yes, you are, sir. We hear you.
Good.
Thank you.
Very briefly before you get into the questions, Andy, thank you so much. This is complicated because when we go back now to a legalistic approach in this environment, yes, our Article 1 tells it. It's the exploration and use of outer space, and astronomy is part of space exploration. We can all accept that. All nations understand that. But when we go to Article 6 of OST, we get into trouble, because there it says States parties to the treaty shall bear international responsibility for national activities in outer space. What if the drafters of the Outer Space Treaty in 1967 had said, states parties to the treaty shall bear international responsibility for national outer space activities? It would have been completely different. And states legislating at the domestic level on their implementation of the rights and obligations of the Outer Space Treaty would have had the headache of including astronomy into their national space legislation. But given Article 6, where it really stipulates activities in outer space, we have a glitch there regarding terrestrial astronomy. Not the Hubble telescope, because that is apparently an activity in outer space. But for terrestrial astronomy, I think this is something that we need to discuss further. And I am pleased to see that STSC this year agreed, as you said, to have this new item, Dark and Quiet Skies for Science and Society, as a single item, one-year item for next year. Given that, it takes an objection to get that item out of the agenda. There must be a motion next year to keep it, and then somebody has to object. And this is good. It's on the agenda. Thank you so much, Andy.
Absolutely. Thank you, Nicholas, for bringing it home to us with, you know, the very fine language of the Outer Space Treaty and how it applies to, you know, our today's world. I mean, we really are coming to grips and struggling in a lot of ways with this. And Dr. Williams, we are very appreciative of your talk today and what you have presented us. And we, of course, are following this matter closely in our committees and the legal subcommittee, and there are so many connections to you know, all of our work in outer space when it comes to terrestrial astronomy, and how much we want to avoid disruption of that activity because it's so crucial to all, even the space activities that we're doing, as you had pointed out. So with that, I thank you very much again for everything. Please, back over to you, Major, and thank you.
So we now start with our last presentation. I'm gonna apologize in advance if I don't pronounce right the name of our presenter. We're presenting Mr. Kai Hughes Roll, former chair of the LSE, who's gonna present on Towards a Regimen for Space Traffic Management and Governance Perspectives. Mr. Roll, the floor is yours.
Thank you, Major. That was a wonderful introduction and almost perfectly pronounced. This is why I also accept your kind invitation to visit Chile at the beautiful places for astronomy. So thank you very much for having me at your super interesting course. I see there are still almost 90 participants there. I will do my very best that this is the presentation last but not least. So I will try to come up with something interesting, I hope, for you. Would you please share my presentation? So until this is uploaded, I can maybe say the following. In my mind, I'm currently still in Latin America because a few minutes ago I registered a video for the regional moot court competition, which IISL is organizing. And in the region of Latin America, the finals are taking place today and tomorrow. And I made a short address to the teams which will be competing in the finals tomorrow for the winners of the regional round of our moot court competition. So I'm on the same continent and continue now with my presentation on space traffic management, and I was asked to talk about the governance perspective. Next chart, please. So IISL, the International Institute of Space Law, has been dealing quite a lot already with space traffic management. And one word on IISL, we are the Global Association of Space Lawyers, and I'm sure and I see that a number of participants, also panelists, are members of IISL. We have members from almost 50 countries on all continents, and we also bring together space lawyers from governments, from agencies, as well as from academia and industry. But what we are particularly proud of is that we get more and more young people joining the Institute. And this is something which is very, very promising, I should say, that the young generation is interested in space law, in presenting and also in supporting to maintain the rule of law in outer space. Now, space traffic management, of course, is a challenge to the rule of law, how to behave in outer space. And we are certainly not alone as IISL in looking into these issues and into the issue of space traffic management. We have a joint partnership with the International Academy of Astronautics and the International Astronautical Federation to bring in the legal, the technical, the economic aspects, so in a comprehensive way to look at space traffic management. And at the next conference, the IAC, we will do a presentation on what we have been doing so far. Now, STM has also been for years now, many years now, a session theme for our colloquia on outer space law. And this brought together, I think, almost 100 presentations already over time on space traffic management. And these are a resource to draw on when it comes to the regulatory and legal aspects of STM. We were also participating in the path-breaking IAA studies on STM, which were supported and also written to a large extent by IISL, which were presented in 2006 and 2018. And I will come back to that at the end of my presentation. And this is very important to note, because STM is not anymore an academic idea or issue, but the legal subcommittee of UN Corpus has in 2015 decided to establish from 2016, so already in practice in 6 years, an agenda item on space traffic management. And we are extremely honored that IISL, together with ECSL, the European Center of Space Law, set up the topic of space traffic management for its symposium, annual symposium at the legal subcommittee. And this quite clearly initiated also that STM became an agenda item. Next chart, please. So STM is an issue of and for regulation, both on the national as well as on the multilateral level. So on the multilateral level, what we have to aim at are harmonized norms, rules, and standard. And I stress that it has to be harmonized, because otherwise we might turn to flags of convenience and competition, and also an understanding of the regulation which is distorted. And on the national level, we have to implement that through national legislation and regulation, as well as through the authorization processes which governments have to set up, and the supervision they are obliged to undertake vis-à-vis the space activities of its nationals. Now, if the national approach is not in line with the multilateral approach, and if the multilateral approach, which means the member states of the United Nations, come to a joint understanding of what to do and how to do, then it can be possible that single national legislations and regulations may determine what kind of rules and standards internationally will be applied. So we would speak from extraterritorial extension of national regulation without and bypassing the multilateral development. So that means that all countries, and I'm also addressing here in this context the Latin American countries, have to get engaged in thinking, assessing, and then developing jointly the multilateral harmonized norms, rules, and standards, and not leave it to others. So get engaged. Next chart, please. And I mentioned national obligations, and I call again, get engaged, because we have the obligation of the states parties to the treaties, and here in particular the Outer Space Treaty, Article 6, to establish national legislation in order to authorize and supervise commercial and private space activities. For that purpose, we have written a very short, as you can see, very short position paper, because a lot of countries, even the majority of those who are parties of the Outer Space Treaties, have not yet been engaged and have not passed such national space legislations. And this is why we said we have to call upon these member states that they actually come up with this. IASL is ready and happy to support, as is the UN Office for Outer Space Affairs, and you also have brilliant space lawyers on your continent, but you have to listen to them, and you have, I'm now addressing the governments or the governmental representatives, you actually have to set up such national legislation and regulation, and through that also have the opportunity to shape together the rules and regulations for space traffic management. Next chart, please. And here we are with the key governance aspects for space traffic management. And from what I heard from the previous presentations, you will immediately realize that there are quite a few which have already been mentioned and which show that the STM concept is very much encompassing and covering and touching a lot, maybe even almost all the areas of space activities and space utilization. So what we need is data acquisition, data sharing, and notification rules, which are to be done and presented in a transparent manner that everybody, all the participants in space activities, can benefit from them. We will then have to see that we establish technical standards for authorization, licensing, and supervision. Not trivial, but it has to be done, and it has to be the core also of any national and multilateral regime. We will then have to come up, and this is what I guess is most haptic. You immediately understand what it is, and this is traffic rules in orbit. Who can fly where? Do we have to restrict this? Do we have to have certain zones here? Are there priorities for human spaceflight, for example, vis-a-vis satellites? These will be questions which will be dealt with and which will determine then the behavior in outer space. We will have to come up with new rules, possibly of responsibility and liability. We will also have to have, since we do not yet have that in a basic and accepted sense, we have to find arbitration mechanisms. And even, and this is something new for space law, and it's still new for international law, we have to find enforcement mechanisms. And then we have to see for an institutional setup. Can I have the next chart, please? And there I turn to the results of the recent IAA study, which came up with two different governance approaches. One approach, incremental bottom-up, and then you can imagine that the other approach is top-down. So if we find an STM regime, which is encompassing what I just said and explained on the previous chart, we can come bottom-up. We find out what is important, 10, 15 issues possibly, and then we work on these issues separately. And this could, of course, lead to a coexisting of regulatory instruments for each of these areas I mentioned, which may constitute building blocks, out of which then a comprehensive regime could emerge. This would, of course, allow individual solutions, also at domestic level, and it would facilitate to speed up also the activities in the one or the other field. But, and there comes the problem, the flexibility to tackle the issues is certainly good, but the big risk is fragmentation, that you have then a number of dispersed regulatory elements. Maybe they don't even fit together. Maybe we have one on the issue of light pollution, one on something else, and they might compete even with each other, and they are not coherent. So advantages, disadvantages. Next chart, please. And the same we have with the top-down approach. On the one hand, it's of course good and positive to have everything in one hand, in one go, but then you have to see how difficult it is to bring all these elements I mentioned under one heading, and this takes time. And this is something where we have a problem, of course, because we do not have really the instruments to handle that, and we usually then take in multilateral settings very much time. And this is, I guess, one of the points where also, again, the balance has to be taken, and it's very difficult to take that balance. But just 2 words on how such a top-down comprehensive governance approach could look like. We could call it the ITU approach, because the ITU has a wonderful architecture, a legal architecture, which can now be compared with a complementary approach for space traffic management. Now, we could set up an outer space convention comparable to the ITU Constitution and Convention, which is rather rarely updated. We could have on the lower level the outer space traffic rules, which could be comparable to ITU radio regulations. And we could have on a lower level outer space traffic technical standards, comparable to the ITU standardization organization, where also, and this is important because we don't have that in UN COPUOS, where the industry, so non-governmental stakeholders, as I put it here, are involved or would be involved. So that would be a new architecture. But, and I should stress that, not doing away with what we have as the basic principles of space law in the Outer Space Treaty in particular, but transferring that in particular into the Outer Space Convention. Nobody wants to do away with the freedom of use or the non-appropriation and the other principles which have guided our activities so well. But we have to add to these principles which are dealing with the status of outer space and the actors. We have to add to that rules on behavior. So that's the basic idea and understanding of space traffic management, of the legal aspects, as well as of the government aspects. And if you now show the last chart, I can sum it up in one point, that as it is the motto of the IISL. Yes, please, the next one. As it is the motto of IISL, we have to maintain the rule of law in outer space. And if we do not make appropriate and good regulation in the sense that it actually meets the expectations of the actors, and it also is efficient, but also just, and that it's fair, and that it also responds to the needs of the newcomers or the latecomers. So no simple first come, first served, no simple we can do it, the billionaires can do it, so let them do it. We have to maintain the basic principles of outer space law and to translate that into rules of behavior through space traffic management. Thank you very much for your attention. I hope I did not take too long and not to extend the meeting time, because it obviously is the last presentation for today, but I hope I could a little bit engage you also in the topic, which is of paramount importance to the future of space law, and in particular to the future of space activities. Thank you.
Thank you so much, Kaiue. That was excellent, and we really appreciate your take on these on this very important matter. And yes, it's been discussed in the legal subcommittee for a number of years now. And maybe you can give some thoughts that you might have on, how do we go from where we are now, where we don't have any real space traffic management. Even a definition is even an issue of what we have, and the difficulties that we have even in the current system, where there are conjunction messages and conjunction warnings that are given, and how to institutionalize those into the behaviors of actors, and what kind of information sharing tools do you think we can think about that would facilitate this? And I note that there's the idea of a convention that's excellent, and of course we're all space lawyers are looking for more binding rules, but it somehow also eludes us in the political climate that we're in. So maybe you can speak a little bit about those topics. Thank you.
Yeah, thank you for the question, Michael. Indeed, there will be key issues which we have to tackle. Very difficult to solve each of them, but I think we have to start with a grander idea. Otherwise, we will end up nowhere. So we have to pick the issues which we can solve easily, the low-hanging fruits, but we must never forget where we will be heading to, and heading to is a comprehensive regime. Now, there are a number of activities we can easily approach. We should not approach the definition, because as everybody knows, definitions are very difficult to come up with. We of course presented one in the IAA reports, and I must say we were really proud when we saw that they have been this definition has been used by NASA appropriation acts in the US Congress. So we were super surprised to see that, but fine. Now, in an international context, working on definitions and saying, before we don't have a definition, we don't start with real work. This is the killer. See for space weapons, for example. So it can be blocked by everybody who has to fiddle around with the definition. So start off with what you can do, but keep in mind what is happening. Now, what is extremely important is, first of all, that everybody thinks and approaches the issue with the kind of readiness to create transparency. Now we don't really have transparency. What is fantastic that the US provides their data, and we see more and more actors who can also provide additional data. And we see also commercial actors and private actors which work with the data and provide information and services for that. So that has to be better founded and in a way organized so that everybody is a co-owner of that. This is number one. And I see also questions in the chat which are responding to that or pointing to it. So we absolutely have to find rules and regulations and standards that the information which is provided based on data is reliable and is accessible to everybody. Otherwise, it's useless because also on the street, if you don't know where the other cars are or the other participants of traffic, then it's super dangerous. But there you have your own eyes. In outer space, you have to rely on observation data, rely on information derived from that data. And there we have to come to a point where the reliability and also the openness and transparency is important. And then the second point, and I stop then here for further questions. The second point, I think, is that this spirit of transparency has also to lead to a point where you do not inform the others after you have done something, after you have launched or after you have done a maneuver. No, you have to inform, notify in advance. So everybody is aware what you are doing. When you move on the GSO from one position to the other, tell it to the others so that they can prepare and not try to sneak and move and then, oops, something happens, but nobody knew before. So these are two things which are hyper important, I would say. And it is also, as I said, a matter of approach, philosophy even, but more or less a policy, which we should adopt on the international level.
Very interesting, and thank you so much, sir. I really I share many of your views. Absolutely, Nicholas, do you have a comment? Thank you.
Yes, thank you so much for allowing me. And sorry, now I have my Hawaii shirt today.
Nicholas, I did not allow you. Michael did.
Caio, thank you so much for your presentation. And I will not be long, but there is a point that I've been thinking about some time. So if we look at the adoption of the long-term sustainability guidelines of COPUS, the LTS guidelines, and they are technical and at the same time, they are highly policy-oriented. So it's really an inherent complexity in those guidelines for states to implement. Okay, it's a non-legally binding voluntary instrument, but if I put to you 4 points, enhanced capacity building and awareness about the importance of those guidelines, increased dialogue with private sector actors, meaning governments and their private sector actors within their jurisdiction. Then organized reporting on the implementation of the LTS guidelines and further development. That means at the international level. And lastly, a more structured information exchange on space objects and events, which encompasses the avoidance of orbital collisions, orbital breakups, uncontrolled reentries. So if all of that is being dealt with at the global level, meaning COPUS, do you see an emerging space traffic management regime, or I would say the fabrics of future space traffic management that could come out of such a continuous work?
Oh, absolutely, Niklas. And you point to the activities of the group, which are fantastic. We have there the incremental bottom-up approach in NUCE, and for the first time amongst the governments, even if non-binding, but identified specific areas which have to be and can be dealt with They are not really low-hanging fruits. It was rather high, middle high, I would say. It was a lot of work and negotiation. But this is exactly the spirit of tackling single issues, but then also hoping that everything would be coherent in the end. We see many other such elements. I think I can mention the TCBM working groups or expert groups established by the UN Secretary General. We have even private initiatives like the Space Data Association, which is doing a kind of coordinated space traffic management amongst its members, the big operators on GSO. So we see already that a lot of things are happening also in the space debris field, which is getting closer and closer to STM through IADC and also others. So what you describe and what I added to is the bottom-up approach, and it's working well. We go incremental step by step. The big issue will actually be how to bind that together. Does it make sense all together? How to fill the gaps, and then how to maintain also the principles of current space law, and how to implant that into a then truly coherent approach. And for this, we have to see that even though we now get experience with specific guidelines and the specific elements which are contained in the guidelines, but at some point in time, we have to assess whether we make more and more guidelines and or everything falls in place, or whether we have to make the big chapeau over these guidelines, also based on the experience which we then have in 5 years or maybe also in 10 years, if it's not too late at that time, and then put something properly together.
Thank you.
Thank you. I just have one kind of a purely legalistic way of looking at things. We have, of course, the liability convention, and we have the potential liability on states for damage caused by their national activities in outer space, and that being under a fault regime. Now, if we look at the liability convention in conjunction with the Outer Space Treaty and Article 6, if there are space traffic management information that's available for operators to use, private sector operators, could a state be considered at fault for not requiring, and indeed in its continuing supervision of its non-governmental entities under Article 6, could it be found to be at fault for not requiring its own operators to abide by space situational awareness information that is made available? What do you think the driving hook would be for countries to make such an oversight? Do you think that that potential liability is enough for them to say, I want to control risk, therefore I am going to control my non-governmental entities in this regard? Or do you think that there should be some other more overarching obligation on states, and just instead of just potential liability under the liability convention? What are your thoughts on that as a way to push states, say, into this realm?
Yeah, well, absolutely. You point at two different issues, and they are both extremely relevant. The one is the international setup, and these are the points we usually put into the problems and cases of our moot courts, so that the students can then go up and down the regulations and the provisions of the treaties, and then come up with their ideas. So we are open in this respect to read the obligations of the states in a way depending simply on the agreement and understanding of the state parties for that purpose. This means also that at some point in time, we will have to deal with things which are not be dealt with or cannot be dealt with in UN corpus, but which have to be dealt with in conferences of the state parties to treaties. So also a new and different way of space law development, space law making. Second point is you point at the national level. And this is what I wanted to allude to in my presentation, that it's extremely important that there is the national level which implements any international obligations. And the question always will be, is what has been created on the international level actually implementable? Does it make sense? Where are the problems? Will it be done in a coordinated way? Does it give room even for distorting competition or provide advantages to the one or the other country? We have no experience yet with any of the guidelines or any of the other provisions. This is why we in the IISL also put forward this paper. And this is something where we certainly need more thinking, but even more experience. We are only at the beginning of identifying and then implementing certain activities, and this will be very important, in particular also for the assessment cycles of the guidelines. What is the outcome and whether they are actually working, or how we have to then come up with something new and different. And in my view, this is still timely. It's quite good. We still have some time, even if things like the mega constellations are absolutely critical. But there again, this is not an international problem. It's a problem of a national regulator and an institution, or the institution, the government, which is licensing on international space law and obligations, but also on national rules, which are derived from that. And this is something where we have to be extremely attentive, we have to understand the interrelationship, and then accordingly make proposals, and in particular in the UN corpus, in the legal subcommittee, act on that.
Yeah, absolutely. Thank you so much. And yes, I have the fear essentially that, you know, we are one major catastrophic collision away from realizing we need such rules in place, but then the horse has, you know, escaped from the barn, basically. And so with that, I really thank you so much for your contribution, and really this goes to a lot of what we will see in the future. We need a system that we can manage all of these satellites that we're going to be putting up there. We need to have a common understanding and approach to regulating non-governmental entities that are operating these constellations and these satellites, and to avoid essentially, and to abide by the treaty and avoid harmful interference with the activities of other states, to pay due regard, to ensure that we have long-term sustainability of outer space. We've worked a lot on all different areas over the years, and in many ways, it's space traffic management which brings it all together. And that, I think, is a huge Herculean task, but something that definitely needs to be done. And I thank you so much for your work in this area. You've done a lot over the years. I noticed that we have included in the chat a link to a lot of work that you've already done here, a joint project with the IISL, the IAF, the IAA. This is excellent contributions, and we really hope to have this in front of the international community, in front of the legal subcommittee, for states to consider these things and keep considering them. And it's great that we have an agenda item on this. And with that, I'd like to thank you very much again and for your contribution. And that indeed brings us to the end of our day's activities today. And we've had a lot of really interesting speakers, absolutely. Very, very well received. We are very happy and delighted that we have had such great contributions over today. And with that, unless there are any other comments from our panelists, then I would like to thank you all again very much. Remind folks that we are beginning tomorrow at 9 a.m. sharp Santiago time, 3 o'clock Vienna time. And you're all welcome to come and participate again. And we look forward to a very interesting day tomorrow with on some very juicy topics in space law, where it really comes to play with what we are looking forward in the future with the space resources issues. We are excited about that. So everybody, thank you so much again. Have a wonderful evening, good morning, good evening, and good day to you all wherever you are. Thank you again, and have a wonderful day. Thank you.